a lot to read appeals. Urgency is, contempt.
Contempt is going. That is an urgency.
It's harder to mention in law.
Pass on all the memo. Pass on all the memos. Pass on all the memos. So let us see. Pass on.
It's harder to make a mention in item number 48. Recommendation to court sanction.
Let it be called, may not be called. Let us see. Wait, it will be called just now. Don't worry. It will call just now. Yes, call the. See,
Just find the counter affidavit you're not sure.
whenever we send me the file in the chamber, do one thing. When it is a writ appeal, then flag that particular order which is under challenge. And grappling with finding the this. Yes, I have seen that, but she has filed a counter just now. Have you received the copy?
Lordship, I'll serve the copy.
Ms. Patnaik, the learned additional government advocate, submits that she has filed the counter affidavit, but the copy thereof could not be served upon the learned advocate appearing for the petitioner. So she undertakes to serve the copy of the counter affidavit in course of this day. This is the matter.
17th. Item number 2.
I am on virtual mode, my lord.
Yes.
I have been engaged by MCL, but suddenly I have
By?
MCL for a petitioner.
Okay.
I am suddenly
There are
taken.
batch of petitions.
Yes, my lord.
And the point.
I have suddenly taken ill. To accommodate.
Is
Mr. He is associated.
I'm my senior advocate also to time. That's why I put it day after tomorrow. It's not well today. We should not object.
No, maybe
Day after tomorrow.
See,
maybe 15th. Can it be? If no objection, can it be after holidays?
Before holiday, we got getting job. 2014 recruitment process.
that we have seen, the horizontal and vertical reservations.
Yes.
Yes, that is the position. That is the position.
One day when we take it off. The next week, my next year is actually not there. That is why that's the
Day after tomorrow.
for some personal medical reasons.
So he's gone for a better checkup somewhere else. So what? Yes, immediately after.
Yes.
Counsel.
Don't worry. I have prepared myself in the matter. It will not take much time.
Copy not.
I have gone through it.
Copy not solved.
Yes. Anyhow.
Last
Haripad Mahanti,
On behalf of Mr. Himanshu Sena,
just
Maybe I will request the advocate to serve the copy.
just help
The
your
advocate on record.
just help your colleagues by furnishing copies.
Yes,
You have not
but
received it.
last order last again.
yes, I am
Yes.
first.
Mr. Counsel, subject to my lord's approval, normally all the benches of previous benches also on furnishing pen drive, we give the relevant copies of the. You can have that soft copy.
In any way, I'll supply.
All the procedural mix.
Subject to your approval.
No.
My lord, I will anyway supply.
You can have, if suppose he could not, You can take from here. Your relevant pages and papers will be.
Fixed date here, so that,
Immediately, he has gone for a medical checkup somewhere else. So he requested for it. It's a brethren fraternity, sir. Somebody
no,
suffers.
well, not basic.
So
Specific date,
immediately after that.
Yes,
Specific date.
23rd June.
Yes.
23rd June.
Okay.
Item number 3.
Immediately.
I will ensure.
What I have said.
Record an order. The counsel is appearing for the respective parties shall exchange their pleadings in the meantime.
Or that's.
Item number 3.
But if we kindly look at the review order.
What is this order, sir? What is this? What is the challenge?
Right.
I'm really at loss
Yes.
when I say that how can this order can be challenged?
Right. I also asked the same question to myself
So,
when I have been allowed to draw it.
so you know it was not that withdrawal. On your prayer, it was withdrawal.
Right.
So once you make a prayer for withdrawal, can you file an appeal? I'm really
The
surprised.
Lordship view is not only that, that is also the Supreme Court judgment.
No, 82 Supreme Court is there.
82-1249.
I'm saying that the state of Maharashtra versus Ramdas Srinivas Nayak.
82-1249.
Yes.
Kindly see the judgment. No, there is a just silver line. If I can come with
No,
that,
not silver line. There is no.
there is it. Kindly see.
There is no dark cloud that you can see a silver line in between.
But I have two options. I am conscious
You
of.
go there. You go there.
I should go there. But if your Lordship will just hear me for a minute, I think I can persuade my lords to examine this. What is the issue here? I believe, Lord, at least for a minute, if your Lordship will just permit me to address your Lordship, then I believe.
I am bound by my own judgments there.
Lord, your Lordship will see then first 82. Lord, I am conscious of the position of.
Have you seen the languages? The
Look,
words so strong.
I
Nobody can even contradict by filing
Look,
an affidavit.
this is
That's so
considered-
strong words.
This is considered to be a Bible on this proposition. I know. 82 Supreme Court 1249 is considered to be a Bible on this point.
Absolutely.
Lord, there is no escape from this. But there is one silver line escape saying that in exceptional cases, the appellate court can permit that kindly silver. If I can come within that, come. Otherwise, I'll go back to the same judge.
What prompted you to make a prayer for withdrawal?
But we have not made a prayer.
Then go is a recording of an
But
event and the
that's
event
right.
is wrong.
But still,
Then-
on the facts of this case, if the Lordship can examine this only, but it is only contravention of Article 308. There is no dispute that the property is my recorded property. There is no dispute. But there are two reports. One is the civil judge junior division's report that says that my property is being taken over by IDCO without making payment of compensation. But litany of judgments are.
How can a civil judge junior division make a report?
But that is on the basis of the order passed by this Honorable Court.
Can it be?
But the Honorable Court
I'm
was.
asking you are a veteran in the profession. Tell me, can a writ court direct the civil judge junior division to make an inquiry like an authority?
Why it was directed?
I have seen in some of the matters these are.
My lords, kindly see, what was the occasion for that?
The judge is invested to go and make an inquiry and submit the report.
But why that was
The
directed?
writ.
But why? I'm sorry.
They're not. They're the judicial officers. Their primary object or the role is to adjudicate. They can't be substituted like a.
But what was the, sorry. I'm so sorry.
That if their Supreme Court is applicated in many.
Tahsildar's reports that there is no overlapping. Salary Dumping Commission reports that there is overlap. This was the conflicting report placed before the court. So to draw out a balance, it was directed that hold an impartial inquiry about this, whether the private property is taken over by IDCO or not. It's a small issue of IDCO is taking over my property without making payment of compensation. That's all. But if today, without entering into all this, your Lordship may direct the IDCO To hold even an impartial inquiry, my property, if they are taking over, I am entitled to compensation. That's all, man. But I am about the poor citizen.
Who was the learned advocate who appeared before the single bench?
Saurabh Bhuiya.
Is he appearing in this matter?
No.
And
It would have been a case of review.
then I'm talking about 1997 Supreme Court page 1007.
I cannot. I think I cannot.
Please find out that judgment. That was a case of a review. And
Review.
there, I'm telling you, the Supreme Court, what is noticed was,
Yes.
the Supreme Court find that a lawyer who appears and argues the matter,
Right.
and thereafter the review is filed by
Yes.
another set of lawyers.
That's not permissible. 97
And
Supreme Court.
then the Supreme Court has come up very heavily on that.
Not 97.
And it says that you cannot reopen these issues.
Absolutely.
That what has been argued there,
Yes.
you cannot come forward that
Yes,
this
yes,
point was not argued. This is a,
97. Relied 2013. The same proposition. Look, today. Look,
I always know the basic foundation.
I know.
And then the edifice is something land.
Match your lordship, Lord. So long we have been appearing before your lordship within this short span of time. I am convinced that to come and appear before your lordship, that requires a burning of a night. That requires.
So that is a whole difficulty,
I am
sir.
not speaking on your lordship's base.
No.
Lord, today.
This is, I'm telling you, that is what is troubling me a lot. Because the Supreme Court has said, I tell you very frankly, if we entertain, then there are two things that would come.
Right.
First is that the learned advocate who appeared for your client
Yes.
in the before the single bench,
Yes.
he had made certain submissions which was not within his instruction from the client.
That should be clear.
That means that we are really accepting the misconduct on the part of an advocate.
Yes.
And if we accept the misconduct,
Yes. It has to.
it has a larger ramification and larger impact.
Without.
That is what that troubles me. I tell you very frankly.
If I can take liberty, that let the learned lawyer. But there is no conflict.
Now, secondly, if you say that this has been wrong recording of an event, the learned advocate never submitted.
Then it has to
Then
go back to
also,
the same
then I
court.
will have to go there and say that it was not submitted, and that too.
One.
Now I'm saying that this is what exceptional circumstances is something different. It should be read in the context it is so used.
You only
The-
have discussion.
This is what I'm saying.
Can't claim it as a
The
matter of.
problem is that lawyer is not here.
No, I should get
And
it.
now when you say
I
we do not know whether he made a submission or he did not
My
make a
lords, great respect. I
The
should
learned
get it here.
advocate who appeared for the other side would also have to say that whether its submission was made or not made.
Lordship's opinion. Lordship,
So very
give me some
difficult.
time. Give me some time. I tell the client that get the lawyer. Otherwise, I'll not update.
Mr. Ras, again another problem.
Right.
We are in writ appeal.
I cannot.
Oh, that is what I'm saying. Appellate court.
Here, Lordship exercise the same jurisdiction to that of the
It's
announcing.
not in that sense of a appellate authority.
Give me some time. Let me tell the client to get the lawyer before you.
Whatever I do not know, then a lot of things will come.
See, man.
I do not really interested in opening the Pandora box.
My
I think that has larger impact.
conscious of every adversity, my lord. But still, then I am before
So
my
that
lord.
is why I want to put rest without any.
know our limitations.
Mr. Rath, Vivekananda Bhuiya is also amicus curiae here. You are close. You are close friend.
Where? Vivekananda? Where is?
Achha,
No.
Mr. Bhuiya and his son, they were appearing. They were appearing. But I think he will not have any difficulty.
Can I show?
Give me some time, you know. Let me try to get him here.
I was showing Annexus 7.
No, I don't know. To be very frank, I am not so much aware of this. No. So same name.
No. Here, Saurav Suman Bhai,
Correct,
petitioner.
correct.
In the last name, you say.
Oh.
Amicus. His father.
Now he is educated.
No, both.
No. He is more aware.
Both are civil lawyers.
I don't know.
Both are civil lawyers. And
Probably that is why they
and
did not come before me.
close friend of yours also.
No, because I do not know, so definitely it does not struck me. But my brother
I not
is,
assist you there.
he is,
Appropriately guide your lordship, my lord. But then your lordship may give me some time. I'll try to resolve the problem. If we are not able, I'll go back to the honorable.
yes. Adjourn for a week.
Right. Too late.
Item number 4.
Item 45 resolution.
On this case, the appellant has filed an order against the honorable single judge. It's a case related to the judgment out of the Madhuri Patil Madam. SLSC Madam, eligible scrutiny.
Madhuri Patil.
Yes, madam.
Yes.
Honorable Apex Court.
Yes.
As for that, there was issuance of a show cause to me for the my caste, my lord, fake caste certificate. After that, the appellant has approached this honorable court. There was interim order. Even after that, they have
Volume 3 SCC, Shiv Kumar Chadha. And what is 1994 Volume 4 SCC, Morgan Stanley. Give, that's the only point in your favor.
my lord,
Bring those two judgments. That's the only point. Do you know what is the point involved here?
my lord,
What?
my lord, in this Madhuri Patil judgment, my lord.
You are again going to Madhuri Patil judgment. There is another point which you can agitate in the appeal.
My lord. I'll get
Based on these two judgments.
the
Find out that Shiv Kumar Chadha's case in your 1993 Volume 3 SCC. I always forget the page.
You are challenging Annexure 5.
Section 5, my lord.
You are challenging order of 14/8/2024.
No, sir.
No, my lord.
Then which order? Oh, sorry.
Order of the single judge, my lord.
Final order.
It's a final order, my lord.
Oh, I am sorry. I'm sorry. Then I'm sorry. Which one?
Order of the honorable single judge, my lord.
Annexure.
15/1/2025.
Okay.
WPC number 18.
No. I read that judgment. That's why I'm asking.
Oh, my lord.
You have appellate remedy.
No, I do not have appellate remedy. That's
Oh.
what the
No, that order is passed by SLSC.
order is.
Screening committee has passed.
That was the final order, my lord.
Huh.
I had
This is what I
challenged the
face the problem.
Yes, ma'am.
You challenge
I
that
do
in
come
writ
to some
petition.
orders I do not know. The please tag that impugned orders. So that
I had challenged that SLSC order in the writ petition, my lord.
Uh-huh.
What the honorable single judge did, my lord.
Against that, there is no remedy.
This
Writ is only the remedy.
Petition is maintainable, my lord. That is my
Sir,
submission.
the state level scrutiny committee.
My lord, single judge is.
Is there any?
Where is the appellate remedy available?
My lord, pursuant
Mr. Appellate, Mr. Subscriber, are you aware of Madhuri Patil review judgment of Justice Anand Patnaik? Have you read that? No appeal in such type of cases.
here the facts are different.
Your Lordship, allow me for 1 minute. I had pursuant to the findings of the state level scrutiny committee and the suggestion to remove him from service and subsequently to withdraw all the benefits which he has availed. That was the direction of the state level scrutiny committee, which my learned friend challenged before this honorable court in a writ petition, where status quo order was passed. Status quo order was passed on 30/8/2024. My lord.
14/8/2024. I could see the order, that is why I.
But Annexure 3, your lordship, may kindly.
Annexure 1, I am looking at.
My lord, I am referring to the order passed pursuant to the by the honorable single judge at Annexure 3, my lord. I am referring to that order, where the order passed by the state level scrutiny committee was the subject matter of challenge.
Subject matter. So,
There the interim order of status quo was passed, but by the time the interim order of status quo was passed, Annexure 4, the order of dismissal was passed by the block education officer, which is 2 days prior to that. My lord. Now the petitioner challenged this order passed by the block education officer in another writ petition before the honorable single judge. The honorable single judge directed that since the order passed by the block education officer is appellable, so your writ is not maintained.
so that order,
Yes.
because the order of SLSC,
Yes.
whether that writ is pending.
Yes, my lord.
That
That
it
the
is
interim.
pending.
Yes.
Both of the reads are pending. Initially, I had filed the show
Oh,
cause.
sir. What was the subject matter of challenge in this writ petition?
Annexure.
It was
Your
my,
dismissal order.
Oh,
my dismissal order.
So
there is a provision for an appeal.
Yes.
we are under misconception that in one writ application, you are challenged both with things because that is consequential. Dismissal of from service is consequent upon the cancellation of your caste certificate, isn't it?
Well.
So against the cancellation of caste certificate by the SLSC, you have challenged the writ application in a different writ petition.
Petition.
So that is pending.
My lord.
During pendency of that, this dismissal from service pursuant to that cancellation of caste certificate, you are challenged. Against that, you have an appellate remedy available. That's why this order.
That's why finding by the court, single judgment.
Satisfied. If he goes to appellate
For the appellate forum, we do.
as long as
Appellate forum will simply dismiss the appeal because that committee has already cancelled the certificate. Nothing more than that. Once the certificate is cancelled and found to be void, then in that event, we cannot get an advantage of that particular void act. No quarrel. Suppose this writ petition, after the dismissal of an appeal is allowed, and the order of the committee cancelling the certificate is set aside, then the entire fulcrum of the situations or the fallout would be that the disciplinary order has to go. And it is affirmed by the appellate court. So was it not advisable to tag both the writ petitions together and then decide that particular point first and then go whether there was any problem?
Here the situation is the dismissal order was passed prior to the interim order passed by the honorable.
based on what?
Please.
Based on what?
Based on that SLC.
So
And your disciplinary, the authority has proceeded on the basis of the order of cancellation, nothing more than that.
Yes.
Solely on the basis of this cancellation order. Now interim order was passed later on, there is no difficulty.
Yes.
I can appreciate it. But suppose that writ petition challenging that order of cancellation is pending. If the writ petition is allowed, it may be, it may not be.
Consequence will follow.
Then what will happen to a disciplinary order?
No, now my respective submission will.
So was it not advisable or desirable to have both the writ petitions together
My lord,
and decide in one go. And if the cancellation order is set aside by the writ court, which it can,
my lord, what my lord suggests that might be a situation where the normal order of dismissal would have been passed. Here, the dismissal order has been passed invoking the jurisdiction conferred
kindly
on the
consider,
authority
sir, there are
under
two-
the OCS
then-
CCA rule.
Then
So that order is appellate.
I am having an academic discussion. Article 226 does not put any fetter in itself in not entertaining the writ petition because of the efficacious remedy of appeal provided in the statute. I believe so. The writ court, now more simple English. The writ court can entertain the writ petition under Article 226.
Yes.
Even if there is a provision for an appeal. No difficult. That's why we wanted to say, suppose if both the writ petitions are tagged together and that writ petition is decided, suppose it's two situations will come. Either set aside the order of cancellation, writ court can, or affirm the order of cancellation. Both, either of these situations. Suppose if it cancels, then the entire foundation of the disciplinary proceeding has to go. And there is no fetter on the part of the writ court in interfering with the punishment inflicted by the disciplinary authority, and also saying that setting aside of those penalties, restoration or reinstatement in service, court can do. Suppose if the writ petition challenging that order of cancellation of certificate is dismissed, then the writ court can also dismiss it that we do not find any infirmity in the order of the disciplinary authority based upon that particular cancellation of the caste certificate. It's no difficult. In both ways, the writ court can. So why not hear out together and now delegating him? What the appellate authority will do? Tell me. He has no choice. He says that on the basis of the certificate, you obtained the service or employment. That certificate was declared as a void or cancelled, whatever. So nothing that what is the wrong which the disciplinary authority has come. Again, he will come into the writ. He can after the appellate authority.
Point raised before the Honorable Single Chair was that the order passed by the disciplinary authority, that is a backdated order. The order was not there on 20. That was the point which was raised.
These are essentially a question of fact. I think when this is the fact which emerged, then it ought to have been before the same judge. What is the number of the other writ petition?
183 of 2025.
183 of 2025.
25, that's it.
You have not challenged this order.
Yes.
You have not challenged this order.
Which was these.
2024.
14/8/2024.
What he says.
He says backdated, he says no, he says backdated.
Let both the matters be heard.
Has to,
But it has to be assigned to a particular bench because
should go.
the matters come.
No, one has to tag with another.
As per
By a
assignment,
judicial order, it does
as
not
per
require
roster,
any
it has to go
assignment.
before two different bench.
I believe it does not require any assignment. If the judicial order says that it has to be heard at one go and delete this, what remains?
One is dependent on the other.
What is that? Which other? No, this is changed here. The order of cancellation. No. The next that order cancelling. Cancelling your certificate, sir.
That is at annexure 2, your lordship. Annexure 2, the relevant portion is that.
Answer 3 is the challenge.
No, this is the final order of the state level scrutiny committee.
That is,
That has been challenged.
this order was challenged in annexure 3, if your lordship will see.
Undeniably, the teacher in Ola Nodal UP school, upper primary school, I believe, upper primary school under BEO for district Bhadra, having selected in the recruitment process, claiming himself under the scheduled caste category as, under the scheduled tribe category. Category on the basis of Sabara certificate as identified ST caste certificate issued by the Tahsildar Board. Subsequently, it was detected that the appellant belonged to a Ila caste, within bracket ST, Ila caste, but obtained the certificate having belonged to ST caste through dubious means. It is brought to the notice of the state level scrutiny committee that the fake certificate was obtained by the petitioner in order to secure the job. And for such reason, it is inevitable to initiate a proceeding against the applicant. The proceeding was initiated and by final order dated 19/7/2024, the said committee found that the Khera caste is not notified in the ST category in the state of Orissa, and therefore such advantage cannot be taken by the appellant, and directed the cancellation of the certificate issued in favor of the appellant. The aforesaid order of the committee, give the full name of the judge, is challenged by the appellant in the independent petition being WP
21442 of 2024. Annexure 3, 21442 of 2024.
WPC number 21442 of 2024. And an interim order
Status quo.
in the form of a status quo as on the date is passed on 30th August 2024. The said resolution is is still pending and has not been decided finally. On the basis of the decision of the said committee, disciplinary proceeding was initiated against the appellant, which culminated into an order of dismissal or removal from service. What?
Directly termination, my lord.
Dismissal.
Directly termination.
Annexure 4.
Termination of service.
Yes, ma'am.
But a dismissal. The word used.
Dismissal of service.
Yes.
Full stop. The said order of the disciplinary authority is challenged by the petitioner in the writ petition with WPC number 19551 of 2024.
My lord, 183 of 2025.
What is this?
Annexure 5. Annexure 5, your lord.
Many. Telling me on the 183 of 2025 of 2024. What is this?
The
Within bracket 24 minutes now. And to WPC number 183 of 2025.
yes.
By the improved order, the single bench was of the view that there is a remedy by way of an appeal provided under the relevant rules when a challenge is made to an order of the disciplinary authority, and therefore relegated the appellant to exhaust such remedy. Next one. The pith and substance of the entire dispute revolves around the decision of the committee in cancelling the scheduled tribe certificate issued in favor of the appellant. And in fact, the disciplinary proceeding was also initiated on the basis thereof. Undeniably, the appellant was selected under the scheduled tribe category in the post of a teacher, and we do not find any incongruity in the action taken by the authorities. The moment the competent authorities cancelled the certificate issued in the favor of the appellant, as the seat, as the post in which the petitioner was appointed was reserved for the scheduled tribe category. The order of the committee is challenged in the other writ petition, as indicated here in above, which has not been decided finally. So, the impact of the decision taken in the said writ petition will decide the fate of the disciplinary proceeding, for the simple reason that it was initiated solely on the basis thereof. Even though the alternative remedy by way of an appeal is provided in the relevant statutory documents
Rules, man.
against the order of punishment imposed upon the delinquent by the disciplinary authority, we do not find any absolute fetter upon the High Court in exercising an power of judicial review under Article 226 of the Constitution of India in dissolving cases. Time and again, it has been highlighted that the exercise of jurisdiction under Article 226 of the Constitution by the High Court is discretionary in nature, more particularly when there is an alternative efficacious remedy provided in the statute. There is no hard and fast rule that the High Court will not entertain the writ petitions under Article 226 of the Constitution, as there is a statutory remedy provided in the statute. And therefore, it is a rule of discretion than a rule of compulsion. Once the writ petition challenging the order of the committee is pending before this court, and the decision to be taken in the said writ petition would impact the decision of the disciplinary authority. It was desirable that both the writ petitions ought to be clubbed together and dispose of analogously. Relegating the appellant to the statutory appellate forum would be an ideal exercise to be undertaken in futility. And therefore, we feel that the impugned order needs interference. Stop. The order impugned is thus set aside. The writ petition being WPC, this number is restored to its original final number. Let this writ petition be heard analogously with the another writ petition, that is 1/8, whatever. Stop. Restored. We heard analogously with earlier. The file may be sent to the Chief Justice for passing an appropriate order in this.
Item number 5.
Yes, somebody was mentioning in the morning. What?
Only day after tomorrow, because there is a
This matter was listed on your mentioning.
Yes, my lord.
When you write the matter, then you should be ready with the matter.
It's near, I'm ready.
Then you ought to have consulted your senior before you mention the matter. You have shown the urgency and then you are asking for an adjournment, sir.
I'm personal degree consults.
Does it formulate a good sense? So,
They have.
I did not go to the let it come after vacations.
Please, sorry, sir. Day after.
Give way to the others.
You are aware, during morning or how many mentions have been? And that's not mention only this is different. Otherwise, we would have another matter. So after getting listed on your mention, and that's a pressure.
Sorry, sir.
Though the matter was mentioned by the appellate citing an urgency, but when the matter is taken up today, an accommodation is sought
Senior.
on the ground of unavailability of the senior counsel. In such view of the matter, that this it could be listed after the well.
Sorry, sir. My. Sir, sorry.
No, sir.
Item number 6.
There are many members of the bar who are really waiting in a queue to get their matter listed. You were privileged, sir, that your matter got listed. Then no.
Item number 6.
There nobody used to say anything. Then when we pass over, then I will be arguing, my lord. I tell you argue? Yes, ma'am. Pass over, I will argue. Only one pass over. How many, what is the time? 5 minutes? Yes, ma'am. Or you can argue just now.
No. In this case, no copy has been sought to us. I am arguing for the Barampur University. No copy has.
Now look,
I am appearing for the my. I am.
you are a defaulter.
No, sir, I have already sought copy to this.
But upon him, you are a writ petitioner.
No. I am appearing for the Barampur University and I am a necessary party.
So you appeared in the single bench.
Mine.
So he appeared before the single bench.
You know this, I am challenging the order of the state government, my lord.
State government also for Barampur University.
I am what, sir?
Barampur University.
Have you not made him a party?
Yes, my lord.
As a respondent,
Sir,
it's
after
not your duty to at least offer a copy of your memo.
After having this matter, my lord, normally,
He has the wakalatama to appear today.
would be my lord, sir.
Yes.
I don't know whether who will be appear from this inversion because but he appeared, you could have offered him a copy.
today he is just filing document because my lord, number of advocates are from
He
here.
appeared before the single bench. You could have offered a copy to him. That you will be appearing before the appellate court.
Number
So
of
if he refuses, then I can understand.
Mr. Pati, subscribe. Not once to this report.
In lead petition, I have appeared. In lead petition.
What we are saying is saying the same thing. Because I am also groomed in the same atmosphere. We always offer a copy to the counsel who appeared in the single bench. Before the single. If he refuses, then come to the division bench and say notice. As he refused to accept. It's never happened, but I will read. Yes.
Item number 6.
So the assumes the bill. There is short copies are day after tomorrow.
6.
Item number 6.
Sorry, they know. There's uniform.
Actually, you have filed that wakalatama in the registry.
Yes, yes.
The name is already appeared.
Obey.
Yeah.
Minus, if I may make a submission, such. Right order dated 8/11/2024, learned single judge arrayed knife weapon just opposite party number 4 minus. He is not arrayed in the registry.
Your copy.
Apology, my copy does not contain right 8/11/2024 minus, learned single judge arrayed opposite party number 4. He has not carried my copy.
And on a lighter note, it reminds me, there's a nostalgic feeling I'm having of my career over there on that side of the room. Whenever we find that there is nothing to argue on merit, take a technical plea. How do you thrash it on the technical plea? Don't put it on a merit. Merit will be very dangerous. So that appears from your, I would say the argument, merit is difficult. Crash it on a technical.
My copy opposite party. I was not.
No, I also used to do it. Don't you? What is the matter?
I have accepted the order under annexure 2, which arises out of section 24 Gram Panchayat Act proceeding of no confidence.
Against the surplus.
Now,
There is a rule, I think the requisition has to be done. The resolution has to be.
Yes, yes,
Rule
yes.
24.
24. Yes, your lordship, I am ordered.
but here, if your lordship, for a moment,
I have in fact put the translated copy in the writ appeal itself, convenience. And what were the questions I have raised that your lordship will get at page 9 of my writ appeal. These are the 4 questions.
It will be page
9, paragraph 8. Parties have addressed and submitted their written notes on these 4 questions.
page
Page 9,
paragraph 8.
Yes.
Just give us 1 minute. Oh, you wanted to say that in order to have the majority, their disqualification was done.
Paving the way, manner, which is
That's true. That's not point the word paving the way.
Which
Who
is
was the member? Who was the member? You were the member of,
Panchayat Samiti.
you were a member.
Yes.
Now, as a sarpanch, since your membership goes, so as a sarpanch, you also.
Yes. The Sarpanch can only be a member to the Panchayat Samiti. Once I go, the number reduced, and that will, and it is also a fact that on 11th, that is prior to my date of vote of confidence, the date was fixed. 35.
First November was the date,
Yes, madam.
and then 11th November was fixed.
Fixed. But on that day,
There was a sizable amount of
imagine
the presence,
but it was,
and you were confident that everybody is siding.
and the documents was on record before the, in the writ petition of signed by 35 members to the Samiti, those who are present. But it is said because of Kalahandi Utsav or the district festival, the presiding officer appointed by the statutory authority could not remain present. So it is adjourned.
He has to conduct the meeting.
Yes, and your lordship knows, under the 3-tier system, whenever the no confidence motion stage comes, there is no question of adjournment. In fact, if this adjournment goes in favor of the person who is facing the no confidence, the question of adjournment of a meeting doesn't arise at all. Anyway, that is not
Is
the
there any bar that
bar. Yes, ma'am.
cannot be adjourned under?
Cannot be adjourned. Cannot be adjourned.
If there is a natural calamity that comes, can it not be adjourned? I'm just asking. You
That
are
is it.
saying that under no circumstances.
That is
I'm
the
just
statutory bar. But for the timing, my lord, that may not be relevant for my consideration. But question is, it is telltale from the action of the opposite party number 3. He was paving the way. Your lordship, I have come. This is one aspect. Second, is squarely hit by Rule 13, my lord. That derogatory and defamatory and assassinating character language should not be used in the resolution. There is an absolute bar. That which I have also quoted, the rule, relevant rule, if your lordship permit me.
This denigrating or
Yes.
derogatory words are used,
Yes. Yes. Yes.
which cannot be read out in the open.
No, not
Okay,
like.
so-
It can be. It has been held that even if it is accepted, other grounds are there. So more or less, the court, Honorable Single Search, with all respect, my lord, says even if it is accepted, then also other allegations are there. And there are five counts or 5 points raised against me. So this is what is the, and I have quoted the findings.
One if proved will disentitle you. Out of 5, if one is proved, that would disentitle you.
My lord, there is no possibility, subject to your lordship appreciation, my lord, there is no possibility or availability of segregating the resolution. Resolution has to be read as a whole. If
There are 5 allegations, or 5 things which the requisitionist have flagged off. They may fail on 4. And if one is proved out of 5,
my lord, here,
will it not disentitle? I'm just asking you one question.
my lord, question is, these are the points to be discussed. Thereafter, the voting will take place. That is the normal procedure. These are the points. So, if such a point would not have been discussed because it is hit by say, Rule 13, so my contention is the whole resolution has to go. It is opposed to Rule
Does it
13.
require any ground to be given? If somebody comes and say, we do not have the confidence in this approach.
Man,
That's the only thing. And if the majority concurs that we do not have a confidence into this approach,
my lord, it's a very pertinent question. Your lordship has-
does it require any kind of a discussion or anything? It is all the magisterial view which is to be
My lord,
accepted in a democratic.
Your lordship is right.
Use
It's a
our
pertinent
polity.
question. It's a
What for?
pertinent question. Whether it should be or these points upon which. But my lord, what is the procedure and practice followed in all electoral system, my lord? The point is to formulate it upon which a discussion has to be carried. Thereafter,
The agenda has to be set.
this is
In
the
a
agenda.
resolution.
My lord,
Now the agenda is that we have no confidence on the surplus.
my lord,
That's an agenda
Well-
one has to discuss.
my lord,
Say there may be a discussion why you are not having a confidence.
my lord.
These are the things which he is doing. I
Well-
do not have a confidence. And
Well-
ultimately, it will go for a vote.
Here, my lord,
Ultimately, it has to go for a vote. If the majority they say that no confidence. we
my lord,
do not, then what
such an agenda could not have been accepted by opposite party number 3 to be put before the house
Why?
because of the Rule 13 bar, my lord. It's all your lordships.
I do not know what is it.
My lord, I have quoted, my lord. For convenience, my lord, my convenience at least. I have quoted.
Stay home. Why you are coming to a panchayat?
That's absolutely.
They were enjoy within the home. Why in the panchayat office?
Unfounded allegations.
Unfounded allegation.
Very easy way to topple someone.
Or consume something, enjoy within the house.
That is what
What
I
is
say.
the panchayat? That office should not be within those days.
They don't say that I was consuming here or there. They say that invariably.
No, they say that you
Come to-
consume somewhere and thereafter you came in the office to enjoy that, the outcome or the after effect.
Well, I'm blessed with the expert on those subjects besides me. Experts of High Court.
So it is better to stay calm, stay enjoy within the house. What is the difficulty?
My friends are always enjoyable company without
So within the house.
The question is, my lord, hit by Rule 13. This is one aspect. Way is telltale from the record.
Giving and consuming is
Different.
Correct. Consuming, my lord, I have not seen the scene.
Consuming and coming and giving and coming.
Different.
It's a hit by. This is one aspect. And the paving the way is absolutely clear and no finding at all on that aspect. My lord, your lordship, just now, nothing can fetter the jurisdiction of this honorable court under section 226.
Who says? Who says?
No,
That any fetter can be put? No problem. It's a very, very ingrained basic structure of the constitution. Cannot be.
in a lighter note, my lord, Justice Sushant Chatterjee was, while holding the court, said, you know what is the parameter of 226? We can touch this moon, we can also touch the sun. Provided
That time
the
Whirlpool-
circumstances
At
come.
that time, Whirlpool was not there.
I think
Whirlpool did not come at that time.
on a lighter side, it needs one clarification.
My lord.
Touching the moon, no problem. It's very cold.
Exception. That's the word we accept.
That's an
Very
exception.
cunningly, the secretary said,
That will absolutely make the person
"No,
experience.
you can ask us to touch the moon so that we will not burn. If you are asking us to touch the sun, then certainly we will. So that is the
Be very
exception.
cautious. That's why this.
My
all the
lord, paving the way.
self-restraint. Don't.
My lord, your lordship may see the appendix 2 at page top of the. I have indicated the dates to.
What do you say, madam?
So
So much of lighter discussion has already been. Allegations are very serious, no doubt about it. If the Sarpanch behaves in such manner, then definitely it does not deserve.
Let's first submission regarding Rule 13, my lords. If I may read the entire rule, my lords, it mentions that it shall not contain argument, ironical expression, or defamatory statement, nor shall it refer to conduct or character of the person, except in their official or public capacity, my lords. The allegation made in the resolution are in official capacity, and that is what is held by the learned single judge at para number 10 in the Indian judgment, my lords. That portion, if I may read, my lords, para 10 of the Indian judgment, my lords. At page number 40.
Another aspect, my lord, there is a clear difference between the signature appearing page 25, 26, and 27. In fact, this is something exceptional in the sense the person who has signed the resolution has not signed the requisition. It has been held.
So your membership has not gone. You are an elected body. All the premiers who act as a Sarpanch, you will still be a member.
No. Because I am directly elected. Directly elected, I will go
Directly elected man.
by the electoral matter. If Sarpanch is being directed, it is not selected among the ward member. Thereafter, the Sarpanch will be.
Sarpanch is normally elected among the elected members.
No. In Odisha,
Then they select.
no. In Odisha, it is direct election.
So he never fought the election.
He fought the election, won the election.
So
Now by this,
so he becomes a member of the.
no, he will not be. He will no more be the member of the panchayat. He will no more. And
He
got elected as Sarpanch. He gets elected.
That is what I am saying. His position as a Sarpanch will go. Because he is elected amongst by the elected persons.
no, my lord. Directly by the voters.
Oh.
That even was.
Directly by
Oh,
voters.
so there is a separate election for Sarpanch.
Yes.
Okay. I have come from a system where.
It was there. It was there.
The members who are selected.
Some year
then
back,
the
it was
members
there.
among themselves, they choose
No,
the Sarpanch.
no.
It was there in Odisha also.
They choose the Sarpanch.
Yes, sir.
So if Sarpanch goes, that means he remain a member of
No,
the
he
panchayat.
will be nowhere. And the paving the way is also proved, and the requisition signature, the honorable single judge has held. Yes, there is a discrepancy, but it doesn't amount to warrants interference. But once there is a finding that there is a clear
I fail to understand.
case, your lordship kindly have a glance. space.
Where is the root? Can I look at the roots? Rules of,
Business.
no, rules of 2015 or what?
Yes, sir.
Yes?
Rules 2014, and this has been annexed to the rules as annexure, my lord, rules of business.
Then what is that, section 24 is of a Gram Panchayat of 64.
Yes, act, my lord.
You were referring
Rule 13 of rules of business appended to 2014 rules. In fact, I have quoted people also. It is under heading of annexure to 2014 rules.
Reading the OLR publication, it is at page number 343. My lords, if my lords are holding the same book.
election.
Only
And it's not sure I could find it.
your lordship, any of one of the book.
After the rule.
After the book.
Yeah, just it is that's why rule of business is not being. Here it is. Rules of business.
Yes, sir.
Which one we want to refer?
Rule 13.
It does not talk about rule of business. Clause 3 does not talk about anything else. Only thing is special meeting. 1/3 total members of the draft budget.
Rule 13, 1-3.
1/3.
Oh, sorry, no. 1-2. It starts with no resolution of question.
Shall be admissible but does not comply with the following conditions. Express definite issue. Not no argument, ironical expressions or defamatory statement. So what is this? It's not a defamatory. What they perceived, what they found, they have just reflected.
Or shall it refer to the conduct or character of person?
What is this character? If somebody has gone there in a very high mood, what more? What more? That
Inherited
is all
condition.
what they say, that he has gone in a very pleasant mood
He-
after consuming something.
He used to come. my
So
lord.
it's a defamatory. Not a defamatory word or ironical expressions. You can't, these are the realities one has said. That he often comes into office in such conditions. That's all. Nothing has been said that he was creating a ruckus or he was creating an non-congenial atmosphere or creating a lot of abuses, having a lot of abuses. Nothing has been said. Only saying that all will come in that condition. Office is not meant for that.
And loss of confidence on this score.
This is true because you are the head.
Yes, ma'am.
You should show the path. If you do not have a control, then how can you control your members?
He think a thing which is not required to be proved, be the tool to topple me. This is one aspect, ma'am.
Not required to be proved means
Sir, there is no basis to making or disapproving.
Sir, there must be some spark. Somebody is will not come in this way. There must be something. Somebody must have seen. It was not a one day or a one incident. It must be a regular feature. And they have said they have nothing on against you except this. Then you should have been told by many. Please correct yourself.
Within my 2.5 years,
Sarpanch, sir.
2.5 years of working, nothing ever was either
But
by
why they found that you are one of the finest person who does it, very fair, everything, but this kind of a conduct, they cannot, because that has that percolated a very wrong signal.
giving the color of this they have. And your lordship has already seen what is the effect of this drawing this in order to see that
No.
paving the way. And moreover, my lord, moreover, page 26.
Only thing is section 24(2)(h) of the act, which says that the adjournment should not be done.
There's no adjournment.
No, not in this question. But question is adjournment should not be done is of the Panchayat Samiti member where I was a signatory and requisition.
You are not challenging that.
But
In the present.
I have said this is an action of the opposite party number 3 to paving the way for the Panchayat Samiti. I have specifically about under paragraph 5 to 7 of the writ petition. If your lordship for a moment will have a glance over the list of the dates and the
In order to go more deep into this, both of you find your short notes of answer. Then decide them. We are fixing this matter on any day. Tell us when you can prepare your short notes of answer. We'll decide. Very interesting.
post.
Whatever.
Post.
That's up to you.
Only thing, my lord, tomorrow is the counting of whole.
So,
They may that may be subject to the result may not be declared.
no, why not? You have lost in two
No.
forums. You have lost in two forums.
First one is not.
Whatever, but the second.
But unless I
Forums you have lost. It is always subject to the result of the appeal. There is no difficulty.
and what my genuine apprehension, my lord, the subsequent once the election the counting is declared, the automatic vacancy is declared by the collector, and the subsequent processes.
There are certain lot of processes which are to be undertaken. This cannot be done in a overnight.
So far as vacating the post is immediate, man.
No, the post maybe fell vacant.
And
Fell vacant. But to fill up that post,
which includes my
requires-
membership. Which
whatever.
includes my membership.
whatever, if it is another day, if you want to fill up, that requires a lot of exercise to be undertaken, not in a so easy way. That requires more than 2 months.
What I beg, my lord, with
So it will be subject to the result of.
what I beg, my lord, with utmost
Or you find it by tomorrow.
tomorrow,
So
my
difficult.
your lordship may
So
say,
decide it tomorrow itself.
your lordship may say, the counting may done. Counting may done. As it is fixed by tomorrow. But it may not take effect. And I will not discharge the duty of Sarpanch. I will not discharge the duty of Sarpanch. Or function as a Sarpanch. That embargo your lordship may, that it will work equally, but
How it matter?
then we will dispose of here and now.
Wanted to.
Convince my brother.
No, my lord,
I'm
wanted
not
to ask
convinced.
something.
If we convince.
That's not the.
We are in different. On all counts, which you have raised now, they are all touchable. Can we substitute any group?
Unless it is-
Possible.
Yes.
The blue paper already, right, in single version. Can I lift up it? We substitute that.
I have to address this.
Diversity of fact,
Yes, madam. I have to address
so that
this
is
issue.
only leave it. Where we can have some observation. Only diversity of facts, except that. Let us start in, I don't think we can interfere.
But
Even clearing portion of law.
I'm conscious, madam. How much I have to.
If it invites two interpretations and one which inures to the benefit for the main object and which has been adopted by the single, then why the legislative appeal or the appellate court will interfere?
Madam,
And in all facts, if there are two
I'll address on
possibilities
this.
has been adopted, then also.
My lord, definitely.
Not.
I will address on this
So
issue as well as
please
my.
come that we are not going to pass. Otherwise, we will decide here and now.
Whatever your lordship feel to be proper, I left it to the domain of your lordship.
After hearing counsel. We find that the question raised in the incident pertains to the question of the several thousands of the which are discussed in the huge jargon. And therefore, we invited the attention of the respective councils to address about. In order to facilitate the determination to be made, both the councils are directed to file their written notes of arguments within.
Before closure, madam. Before closure of the, before vacation.
And the matter to be listed in the vacation.
Vacation, madam.
Honor, before the last day of the functioning of this court,
Ensuing summer. Ensuing summer.
following the ensuing summer vacation. The matter to be listed after the summer.
Yes. Will you get number? Yes.
Here, if your lordship, I will take
Number
number
4 where we entered as a part.
Notice about
opposite part number 4.
4.
He is also required.
Yes.
Item 7.
Picking up that 180. Item listed today in your list, serial number 40. This is to be tagged only.
Yes. Tag with that.
One thing I would like to mention, well, the last item of the item 40 is a fresh matter. Friday, your lordship passed on. Now it has been tagged. So I am get the honorable to get this certified copy.
No difficulty.
Last item.
Let it be reached. 182. We heard along with that.
Yes.
Item number 40.
Yes, call.
Items 8.
It also lordship, said,
Taken up along with 40. Next.
Item 9.
Some 9. Here, issue number is I'm a 2 arms of licensing from 2019-20. And Lord, that license was continued and renewed up to Lord 23-24. During 24-25, Lord, there is some shortfall of law. He couldn't lift, there is
Oh, that is what we have already decided.
Lordships have passed.
Undertaking.
Lordships have ordinary bench has passed.
He is undertaking to lift it.
Yes.
Shortfall.
My lord, the commission has a specific focus noted, my lord.
Then no license
Yeah.
was not
Put
granted.
him unnecessarily, why you will put an exercise on it? He will lift the shortfall. There is no difficulty.
That
You are concerned with the excise duty, sir. You will get an excise duty. Next.
Item number 10.
Advocate General is asked to address your lordship. Unfortunately, he is in Delhi today. Can it come next week?
Well, it's, I have a strong objection to this.
For his appearance in Delhi.
No, man, it's not for that, but for the prayer for adjournment. 2007, a sale was effected by the company court in my favor. From 2007, they went on representing to this court that they would execute the order. They would get the sale deed registered in my favor. And that went on.
If a sale certificate is issued, what more?
The sale certificate, it's a conveyance which has to be done pursuant to an order of the company court.
Is it required?
It is required.
Sale certificate itself is the document of title.
No matter that is sale certificate issued by a company court will not suffice as far as my is setting up an industry and for pledging it to a financial institution for.
What is this, sir? This is what can you argue something beyond it? If the company court has held the auction and the sale is confirmed, then what consequential steps are required to be undertaken?
Position
Is
has
there
been
any
delivered.
objection from any borrower? Is there anything which has come up?
Would your lordship be kind enough to pass it over for a moment because I am not holding the file.
Who is assisting? Who is assisting the learned advocate?
AGS Sashwat Das is addressing. He is arguing a case before the Honorable Justice Sasikant Misra.
When?
Yes, come.
Oh, yes, come.
This is really an open and shut case. Why the learned advocate general should be bothered for this? If the fact was they have said, it is very clear that there was a company court auction. The sale was confirmed by the company court. Now the question is that the certain documents are to be executed.
My lord, here the land has been recorded in the name of government pursuant to the judgment passed by this honorable court.
Through the government, then the government
And
has raised any objection.
Yes.
Has it filed any objection to the confirmation of a sale
My lord, so far as
or for recalling an order?
so far as company court order is concerned, the petitioners, they filed a writ petition for implementation of that company court order. The honorable court directed.
Writ petition filed.
Yes, my lord.
Very interesting.
Then the honorable court directed for to consider the representation.
Oh.
Now that representation was rejected. Now instead of challenging that rejection order, after 15 years the execution case was filed.
15 years.
Yes, my lord. It is beyond the limitation period. 12 years is the limitation, if your lordship knows, for filing of the execution. This was filed after 15 years.
Well, it's
And the execution court, once the execution court pass an order, we have preferred appeal. Now
If the execution is pending, then even if 15 years have elapsed, what is the difficulty?
no, my lord, execution court passed the order which is the subject matter of challenge in this appeal, my lord.
No, they filed an execution case after 15 years of the order
Yes, my lord.
or within the period of limitation.
No, my lord. Limitation is 12 years as per the Limitation Act. The order has to be executed by the executing court. It was filed beyond the period of 12 years, after 15 years.
This has been rejected by the executing court.
No, my lord, this has not been rejected. This has been allowed by the executing court. The executing
You have come for the appeal.
We have come for the appeal.
Correct.
And moreover, the executing court should not have entertained the execution petition in view of the fact that they preferred a writ petition. Honorable Court directed to consider their case. That consideration was rejected. That order of consideration was never challenged. That is staring at them. Till then they filed an execution, then the executing court passed an order and we have preferred appeal. And this is a very valuable piece of land, my lord, 147 acre, 149 acre. That is why I expressed, yes, last occasion, that let this matter be argued by the honorable, by the land agent.
Then how the company was put into possession, there's a liquidation proceeding.
Yes.
So how the company was put into possession? In respect of a land which belonged to the government. Must be on the basis of a lease, must be on the basis
This
of a
land,
must be on the basis of some permission to use and utilize or occupy the property.
My lord, this land belonged to one Mr. Hamilton, who is a Britisher, and he died outside the country. My lord, that land was again taken in a fraudulent manner in the name of trust. Then some of the trustees, they approached this honorable court by filing a writ petition, claiming title over the property. Those writ petitions was dismissed by virtue of a judgment. Now, once after the judgment, the land was recorded in the name of the government. Then the company court proceeding, because the land was IDCO fraudulently sold that land to somebody else because government has not given that land to the IDCO to sell on behalf of the government.
These are
the facts.
absolutely erroneous submissions which have been made. Absolutely erroneous submissions.
I still fail to understand here, when there is a dispute with regard to the title over the property, which court is the competent court to decide?
In the circumstances, there are judgments passed by the.
No, I have not come across any judgment in this regard that the writ court can enter into the title and decide the title. I am not aware. I have to enhance my knowledge. You'll have to correct my knowledge.
Well, may I
It is
just
a civil court which can go there. Cause of action arose under section 34 of the Specific Relief Act. It's a civil court by virtue of section 9 of the Code of Civil Procedure are competent to decide.
What I
Writ court decides the title. I have not come across with this kind of a proposition.
What I pray, my lord, looking into the nature
And
of
therefore, if the property belongs to a particular person, then how it becomes a property of the government?
this is acquired by under the land
How it
acquisition
becomes a property
proceeding.
of the government? Not as cheat, you can't do it. It's an cheat, no.
my lord, once it
Is
is
it an enemy property?
no, my lord, estate, my lord.
I say cheat.
Estate abolition, my lord.
Is it cheat or the enemy property?
This is the government property which was acquired by way of land acquisition.
But the real hurdle is that why you slept in a slumber for.
No, my lord, I did not. I did not. My lord,
What you were doing.
Company code has passed orders one after the other. Till 2012, orders were being passed and they gave a representative. They made a representation before this honorable court that we are going to execute the sale deed. Even though the sale was effected in 2007, money was appropriated, possession was handed over, And they went on representing to the court one after the other, and show that all those orders are before your lordship.
There are two things, sir. When they admit by virtue of section 18, can you put a limitation afresh? You're taking, when you say that they admit, that means you are taking shelter under section 18 of the limitation. Can it revive the limitation?
Well, once they say, make a given undertaking before the
This is what I'm
court.
saying, acknowledgement of their liability.
Yes, Father.
Section 18 of the Limitation Act.
Yes, Father.
Can it apply to this task in an execution proceeding?
That, that I will address your lordship. That I will address your lordship.
Take into account. Because the only provision under the act is
No,
when it can extend is section 18. Read section 18,
Yes.
is an acknowledgement
Yes, Father.
of a debt.
Uh-huh.
It does not talk about.
Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability. A fresh period of limitation shall be computed.
This is what I'm saying, 18. Does it apply?
Acknowledgement was so signed.
So again, you are taking shelter under that,
Yes.
they admitted in one of the proceeding, yes. So I was thinking whether section 18 applies
It
to
applies
execution
for us.
proceeding.
Because they went on saying before this honorable court in the company proceedings.
I'm again
Yes, Father.
saying whether section 18 advantage you can take it for an execution. In an execution proceeding, can you take advantage of section 18? Language, no doubt. It definitely gives a fresh lease of life.
Yes.
So far as limitation is concerned. Under what circumstances? Does it have any impact? There is no other provision in the Limitation Act which gives rise to a fresh period of limitation. There is nothing. There is only one, I think, section 15 of the Limitation Act, which says that if there is a stay or if there is any fetter put,
Yes,
then the limitation would stop.
On that ground also I will argue, because what has happened, may I just put forth the sequence of events. My lords, prior to 1989, this land stood recorded in the name of government. In 1989, 2 writ petitions were filed before this honorable court by a trust, saying that this property initially belonged to one Hamilton trust, and by virtue of certain documents, it has devolved upon them, and they are the owners of the property. This list between the state and the trust went on before this honorable court from 1989 to 2018. In the meantime, what happened in 2002, the land was acquired, not 2002, prior to 2002, it was acquired by the state government on the requisition of a government of Orissa undertaking known as EDCOL. And EDCOL set up a spinning mill on this land. This spinning mill went into liquidation, my lords, in 2002. In the liquidation proceeding before this honorable court, the property was put to sale, and I was the purchaser. Now, the fetter on the execution in my favor was the pendency of the writ petition filed by the trust, which ultimately ended in 2018. After that, my lords, they went on making representation in the meantime, and also pursuant to that they will get the sale deed executed in my favor. That is the representation they went on making before this honorable court. And when all this failed, my lords, I filed the execution proceeding in 2022.
And they executed one. So there is no competition.
And there were 2 properties involved in that order. One, they have already executed a sale deed as pursuant to the company court's the impugned order. The other, they are saying that this is a property which belongs to the trust, etc. Now, this is a trust, my lords, which they have been contesting between 1989 and 2018 when the writ petition was dismissed. The trust writ petition was dismissed.
So what is the fulcrum of the entire episode? Acquisition proceeding before 2002, challenged by the trust.
No, acquisition proceeding was not challenged. The recording of the land in the favor of the government was challenged by the trust.
So if that fails, that means the land remained recorded with the government.
Yes, Professor.
And if you say that the government has settled the land with the ITCO.
ITCO, yes, ITCO.
Or whatever, ITCO. Then the ITCO must have come up.
Yes, ITCO, they took over ITCO.
What was the right of the ITCO?
ITCO was one of the parties in the Company Act proceedings.
Then what was the right of the ITCO? ITCO got the property on the lease or got the property on the basis of a permission or a grant having issued in their favor by the government.
Grant issued in their favor by the government.
By the government.
Well.
So the government remained the owner.
Government remained
only this.
Yes.
So the sale deed would also be only in respect of a user or occupation of the property, not the ownership.
Well, that would be dependent on the rights which were vested on ITCO by that document.
Because you derived your right through
liquidation of ITCO.
The company which has gone under liquidation.
Yes, Professor.
So if that company does not have the inchoate or unfettered right of ownership, then
correct, I will get whatever has been put to liquidation. I would get that much.
The legal principle is nemo dat od non habet.
I cannot get anything more than what my
cannot give or get what the other person does.
What my vendor does not have. This is the situation,
What can be done? Now the limitation, please, because they are harping on a limitation.
No, I have put forth the sequence of events. Your Lordship, let's see that. So, the fetter which your Lordship was referring to in section 15, that fetter could only be discharged in 2018 when the judgment in the writ court.
No, section 18 is something which gives a fresh lease of life to a limitation.
Yes, madam.
So the question is, does it have any application so far as the execution case is concerned? First question. Second, you can take advantage of the exclusion of time under section 15 as well.
Yes, madam.
But the section 15, it says that in computing the period of limitation for any suit or an application for the execution of a decree. So it's a very clear application for execution.
Yes.
The institution or the execution of which has been stayed by the injunction or order.
Yes.
The time of the continuance of the injunction order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded.
Yes, madam.
So that you get a exemption.
89 to 2008.
There was any injunction?
There was a stay order. There was a stay order.
Injunction from putting the decree in execution. Injunction must be of that form, which would fetter you from executing. If there was no fetter, then you can't take it. That's why I say there are two provisions which may come in your aid. You have to ponder upon it under what circumstances it will come. 15 and 18. And there is, to my little knowledge, there is no other provision that would come in your aid.
I will address your Lordship on that.
Please.
Your Lordship may take it up next week, Malak.
Anytime.
Next week, any day. Any day convenient to your Lordship.
Argue on this point. These are the 2 points. Don't take a plea of dema in that sense, thus in a 12-year period of limitation. So, no.
634 of the Companies Act 1956. What it says, your Lordship, just 1 minute, your Lordship is adjourning. Any order made by a court under this act may be enforced in the same manner as a decree made by the
I know it. 1956 Act is gone. That's why I have taken out this limitation act. Because it is to be executed as a decree of a civil court.
Yes.
And the provision of Order 21 will automatically be robbed in.
Yes.
I'm conscious. That's why I'm putting a question.
But
Well, there's one more aspect which your lordship, which of course was argued before the learned company court in the execution proceeding, is section 456 of the Companies Act. Because once the property went into liquidation, it got
Then the official liquidator.
Yes, my lord.
there's no difficulty.
that is the order, my lord. That is the order under
Question is that there are three things. The moment the winding up petition is allowed, now I'm forgetting 438 or 439 of the Companies Act. What is that section?
439. 438. 438. 438.
Once the winding up petition is filed and is allowed, then the company has gone in the liquidations and the official liquidator immediately assumes the charge.
Yes, madam.
And once the official liquidator assumes the charge, then there is the obligation on the part of the official liquidator to see
That the
now there are a hierarchy. Who is
ground debt,
first?
etc., all those things.
Yes. First thing is the workers, then the statutory, then unsecured creditor comes at the last.
Yes.
There's no difficulty. It has to be done in that paragraph.
Yes.
Then it can be put into auction and the company court can put an auction. Company court has put an auction. The property is purchased by an auction purchase.
Yes.
Then the role of the company court ceases to the extent of any adjudication, but with further obligation which flows from the order of the sale that remain with the company court.
And that is what has transparent.
Now, once you put an execution, then in that event, the execution must be within the period of limits.
I'll show it to your lordship that it is within the period of limitation. Your lordship, the entire company court records are also before your lordship. I have put the various orders passed by the company court after the sale was confirmed, between 2007 onwards, after 2007, after the sale was confirmed. There are various orders and the submissions of the state or the undertaking given by the state recorded by the court that the sale deed would be executed by so and so date. I will show it to your lordship. They are all there in the orders of your lordships of this court company.
Come when?
Next week, my lords, any day, your
Any
lordship.
day.
16th, my lords?
16th is the last working day.
No, not 16th, 13th. 13th.
Let it be on 15th.
14th, 13th, 14th, whichever, whatever date. 14th, your lordship may take them.
14th?
15th.
15th.
I
I will not enjoy any issues of that as long as he agrees to a early date.
I may suggest if my lord senior agrees, let it be after vacation so that we both
You can't control the affairs of the learned advocate.
That is the difficulty. That is
So
why
you can't
today he
control.
is not present.
So on the returnable date, if he is again engaged somewhere, then what will happen?
Not there in
certainty
state.
that he is available on 15th or a 14th.
15th we will also.
That's a certainty.
Yes.
So let us fix on 15th and also.
Certainty might not be. Because I get deadline. Today, I can get.
Give instructions.
Yes. Put the matter on 15th. What is the next one?
On 15th. UGC matter that is there in the Honorable Apex Court. My land UGC University Grant Commission matter that is posted before the Honorable Apex Court. So land AG.
So 12, 13th, 14th, whichever date he agrees, 12, 13th, 13th or 14th.
Let it be after vacation so that.
13th or 14th,
So you get yourself ready because these are the points I have already indicated. You have marked yourself, or we can fix it on 12. There's no difference.
Item number 6.
Item number 45. Today's last of both. Because this is an urgent matter where you last.
We are picking up. We are going hurriedly, don't worry.
Let's see. But the
Very
last
hurriedly.
item, we are last.
Yes, we are going hurriedly, don't worry.
Obliged.
Item 16.
Challenges for.
Yes.
I got some challenges though. A part of the common order to annexure 4 your lordships, when the appeal petition of the been rejected on the ground of non-payment of pre-deposit your lordship, which is perverse.
Why reverse?
I have already
That's the
deposited
mandate of the law.
I have deposited the pre-deposit your lordships.
Yes.
I have already made the pre-deposit during filing of appeal your lordships. Prior to filing of appeal, my lord. Prior to filing, I made the pre-deposit your lordships. And by non-speaking order.
So if it is so, then why it has been dismissed, sir?
Kindly have to glance to page 27, your lordships. 27, my lord.
Yes, this is the deposit which you made.
There is 7.5% of the disputed amount of tax, your lordships. And the order is an annex of page 36, your lordships, para 5, my lord.
If it is already deposited, then where is the difficulty? Yes, sir.
I have the instruction.
What is
Amount is reflected in the.
He has shown that he has already deposited
Is it?
before preparing an appeal. Then what remains?
All the cases you have deposited.
Para
In all the
27,
cases.
my lord.
In all the cases you have deposited.
This, I am in item number 6, your lordship. I appeal number 6, your lordship. It's only case, your lordship.
Item number 6 you have received.
My lord.
So
Well,
yeah,
tomorrow.
tomorrow you'll have to take instructions. He has shown the receipt that he has already made a deposit.
You could have telephoned your officer. You could have instructed you over telephone, whether that is 7.5%.
That's exactly.
Percent or not. Today itself you could have done.
Yes, it's fine.
Again, tomorrow it will be listed again the
Day
same.
after tomorrow, we enable the council for the state to take necessary instruction.
Item 17.
Sorry. The petitioner submits that although he made a deposit. Before he prefers in the deed, before the appeal, yet the applicant proceeded to dismiss the appeal for non-compliance of the provision relating to a pre-deposit. The concept of the state is for the exception to take an instruction. This is the record they have to do.
17.
Please don't. Can you unit your lordship's court minutes?
This
Your name is.
order is passed by the Sestat Kolkata.
Funds.
Why, yeah,
The only prayer, minutes, which provides prayer minutes, for which I am there before your lordship. This was a Sikh company for the last 25 years. So minutes,
25 years you are a Sikh company.
minutes.
Have you gone to NCLT?
I'm sorry, minutes.
Have you gone to NCLT?
No.
under IBC?
No.
Have you gone under Sika earlier?
Yes, I was in Sika.
You were in
I
Sika.
was in Sika. They had given us a
Section 18, the
18,
action was done.
18 proposal was granted, my lords. Then, but that fell through. But in the course of 18 proposal, we cleared off the debts of the State Bank, was the biggest creditor at that point of time. We cleared them off, and substantially we have cleared off the OSFC also, and certain other institutional creditors also have been cleared off. So now, my lords, this central exercise is something that cropped up suddenly during the COVID. And I'm not on the merit because your lordships have already run through the on that limited aspect of that order once on the first round of first journey to your lordships court today. And then we went to the Supreme Court. Supreme Court gave us leave to file a review against the lordships order, and also a parallel leave also that to avail the facility of moving the cestat, my lord. Now, I'm before your lordship a very limited point. Point is this, my lord. Sikh company in the last 25 years. In the first round, also, when we had gone to the CGAT, it was CGAT at that point of time, my lord. There, my lords, they had granted us the waiver. Looking at the fact that the industry was forcibly closed down by the powers that be in the state government, that forcibly closed down the running unit. And for only a paltry default of 2 to 3 lakhs rupees, the OSFC seized the amount and brought it to a grinding halt. And then, my lord, this raid, the excise raid, my lords, was even more peculiar. Not a single tin of, my lords, clandestinely manufactured Vanaspati ghee was seized. Not a single tin has been seized anywhere. Yet they have trumped up a demand of more than 2,000 tins of my lords, clandestine removal, production and clandestine. But anyway, those things are supposed to be sorted out at the adjudication forum. And my lord, we were done in during COVID. It was remanded back because of the gross violation of principles of natural justice. It was remanded back by the order was set aside by the CESTAT, and it was sent back to for re-adjudication. Re-adjudication, the clear mandate was you should comply and give them all facilities of cross-examination, also supply them whatever documents they asked for. Now, specifically this document, there was one particular document that we asked for, my lord, so say one document 17A, that is the gate passes, because in our 6-year period for clandestine removal, 3 years, for 3 years, my lord, our stand was, it was under your control. The balance 3 years was control, the control was lifted. But that 3 years period, how can you hold me liable for any clandestine removal? You are in charge. That's the very fundamental point. Anyway, man, I'm also not on that point. They did a same manner. They said in COVID, they suddenly woke up during the COVID period and said that we want to do the trial now. And they said that they're sending us the link. The link never reached us. And my man stood there for a whole day waiting for the link. The link was not supplied to him, my lord. And then, my lord, suddenly we are confronted with the order. Adjudication order was passed literally behind our back. Anyway, my lord, I am also not. Today, my lord, this Sikh company, I am only praying for a limited prayer, subject to my learned.
To extend the time to deposit.
No, my lord, yes, my lord, that is one. Secondly, my lord, installment. Lordship may grant us what's
How much is there?
My lord, 18.5. Completely.
18.5 lakhs is nothing.
My lord, I have.
What?
My lord, see, lordship.
25 of the Central Excise Act says that we'll have to deposit.
I'm acutely aware 2014 amendment was staring on my face. I'm acutely aware. I'm not, that's why I'm not arguing on merits at all.
It comes only 2 lakhs of rupees.
18 lakhs. No, 18 lakhs is the deposit. I was only, if your lordship, munificence of your lordship, I'm fervently praying. Your lordship, my installment price.
Demand was
80
lakhs.
2 crores, 43 lakhs the principal. 2 crores, 43 lakhs of the.
But this is the mandate of the act.
I know, my lord should say, in your lordship, I'm only appealing to your lordship. I can't have a legal submission to this, excepting, my lords, that I'm putting the entire facts on the table before your lordship.
Petition. What do you say?
Yes, it's virtue petition, my lords.
Stringent.
Yes, with that. The first wording is
shall not be entered in appeal. So therefore, I leave it to lordship.
Only thing is.
Yes, Lord, I leave it to lordship.
Again, I say the distinction
Yes,
between
yes, Lord.
maintainability and entertainability.
So therefore, I leave it
You
to
can
lordship.
make an appeal, but the appeal will be a dead letter.
Yes,
unless that-
till compliance of the.
So, it will not be touched by the authority.
Absolutely.
At least to avail, make myself appeal worthy.
No, you'll have to pay the entire amount, sir.
Man.
Tell us the time. No,
Can I just
the installments, no, nothing. You'll have to pay the entire.
satisfies my learned friend? It is satisfied, yes, my lords. It's one that
Right now, you have cleared the, I was party to that.
my lords, that's why your lordship is, my lords, lordship was party to the order.
I was party.
Earlier order, my lords.
Then that went to Supreme Court.
My lords.
If this court has already passed order that it is a mandate.
Yeah,
So I have not done that.
Mandate. Yes, no, now it cannot be done away with.
Well, I can't have
Or it can be
legal,
exempted.
I can't have a legal submission at all.
Yes.
I can't have, lordship may grant me 3 months.
What?
3 months time, extend the time by 3 months.
Whatever the recourse they have to take, they will take. There will not be any moratorium for their action.
That will be.
Oh,
Kindly, my lords, lordship may kindly give me some time. Sometime, 3 months.
No, we grant you 3 months, but there will not be any moratorium on their action. If they want to take a recourse to law, they will continue with that.
No, that will balance again.
Oh.
The appeal would stand dismissed. I will not have any.
No, what is that? Will not be.
No, that's what the order is. That is.
Only Supreme Court, order is, 26/4/2024.
Well, we have there were 3 deposits to be made. I'll explain that. I knew this question was coming, my lord. Sooner or later, this would have faced me.
First division bench
That's two.
decision,
But
first division bench order was January 2020.
man, who I have already.
Supreme Court, April 2020.
Man,
By now, you
But I-
have enjoyed
man.
more than 1.5 years.
man, lordship, what I leave it to your lordship.
Granting you further time.
Man, I leave it to your lordship, my lords. Whatever your lordship, my lords decides.
Oh,
It's,
they have already lost it.
I bow down.
Oh, then.
My lord Justice Raman points out.
Fresh lease of life.
Man, no,
It's the first time you have come.
man, no, I already submitted a second journey to your lordship's court, but I'm only praying fervently whatever time your lordship grants, my lord, I know. And I have deposited 2, the individual deposits have been made. It's only the company's
That
deposit.
is fine. That is fine.
Man, individual deposits we have complied, but only the company's deposit. Amount was a little heavy. So I leave it to your lordship's discretion and grace, my lords, whatever. Whatever your lordship. I can have no submission, my lords, here.
Lordship see page 18 and last paragraph. That is 11/9 was the last date. Page 18, annexure 1, the order of the system. If the tribunal also granted time, even if he has not deported time of filing appeal, he has time granted 11 April
I consent to
2024.
all that. I'm not,
Yes,
I'm not arguing on merits at all. I'm conceding to all that.
Oh, that exercise was given to him.
Man, I'm
That
conceding
was-
to all that and then minutes and before
That
it.
order was passed when?
10/3/2025.
So you had the opportunity. 4 weeks time was given, 1 month.
Yes, no, 11 April.
Practically,
Minutes, whatever time your lordship grants, minutes.
what more?
Just whatever time your lordship grants, minutes. I've been submitting.
Even if we grant time, we will not deposit.
No,
No, we will not.
The generosity was already shown by the I would say the appellate authority.
no, I'll. Minutes.
The tribunal
That
already gave you the real time. 4 weeks he gave, despite all these facts that you have moved to this court, you have gone to this Supreme Court, everything was taken into.
as a debt. That will not be raised.
So that was,
That is also
that's the blessing.
yes. Honorable Supreme Court.
Money.
Limitation not
Money.
to be expected.
It's a six company.
That he has not deposited then.
I have deposited the individual deposits I have made. The company, whatever time, just for, as a last chance, your lordship may grant me 4 weeks. That's the last chance.
Till you try to come with the money, with the check or bankers draft.
Well, as a
We
last
will, we
chance.
will
your lordship.
permit them to accept. Come with the bankers draft. Next week, come with the bankers draft. Show your bona fide that you have the money.
My next week would be little one more vacation. Vacation.
And that would be extending the time limit granted by the tribunal. But tribunal has not committed any error, why should we?
No question of any error, but.
Yes.
If your lordship permits me 2 weeks, Sestat is not on leave, not on vacation, I will make the deposit within 2 weeks.
Not me, you'll have to come with the bankers check in their favor. Not deposit. We want to see the color of money. Show it.
Can your lordship grant me some time to take instructions? Lordship may call it tomorrow, top of the list. Let me take instructions as to the date, and I'll commit a form.
Yes.
I'll commit a form.
Yes. Tomorrow.
Great.
Item number 18.
Support.
Yeah, let me see. First appeal already, let's see. The last appeal here. Just keep pending because I'm putting instruction and because prior to filing of this information, only 3% deposit has been made. And I have filed this memo alerts. The last line of the para number 8 alerts, the reason of 10% deposit for filing appeal before the Honorable Distat against the appeal order dated 22/2/2025. So in this this Honorable Court has been pleased to pass orders in such circumstances. I have modified the
Deposit from the deposit will already be made. Right to go to the tribunal and.
Your lordship, may I admit your lordship, only I have to take,
Because this receipt she has disclosed, then the reason that she is given 10% deposit to go to the tribunal. Second page at the bottom.
your lordship.
So you want to make a cross check.
Your lordship.
Serial number 8.
My lord.
You want to make a cross check.
Your lordship may admit, your lordship may pass the order. Your lordship, if there will be any, I'll mention.
It's always with you.
I'll do the mention.
They are not discussing. Keeping it.
No, paragraph 5, last paragraph 5 of this order. In course of the hearing, the counsel for the professor has to work. This receipt evincing the deposit, the 10% fee deposit being a condition precedent for filing an appeal before the Distat against the order included since such deposit has been made, such a statutory deposit has already been made. And the there shall be a stay of the operation of the order asked by the first appellate court. So, this matter on 25th of June 2000.
In this case, I'm appearing for the opposite party number 1.
For a good reason, your name was verified.
Item 19.
See, page 55, how the calculation, I could page 55 for a moment,
Calculation my life friend is saying after 10%
page 55, for a moment, page 55.
What?
Page 55 is the,
Just find out from them, it is a 10%. If she says it is not a 10%, come, mention, we have kept the matter present. Will definitely interfere if it is not.
your lordship. On the face of this,
Let us see
this
you
seems not
separately from
composite.
them.
it is there.
Once she said that 10% I have deposited, that's all.
Appellate order you let's see balance sum of my life friend is
Whatever,
that.
let us see.
No. Then after 10% balance amount, then 10% of that.
Item 19.
Let's say cancellation order.
Yes.
Item number 20.
Not an order rejecting my application for settlement of disputed tax areas under the direct tax Vivad se Vishwas Tax scheme 2024 is under challenge. Lord will find the impugned order at page 13, Annex 1. Lord will see the pop-up, the screenshot from the portal. So may I place it, please? The application filed in your case for availing the DV SV scheme 2024 for assessment year 2013-14.
So the question is only what is
Whether it was a such case.
133 capital A of the Income Tax Act or 132 of the Income
Yes,
Tax Act?
grateful.
So according to you, there is no bar under section 96 of the Act
Yes,
to avail that particular
the
scheme.
express language of 96,
Yes.
which my lords will find at the scheme is there at Annexure 2. And section 96, my lord will find at page 18.
Page
18 of the. May I please?
yes.
Yes.
So according to you, it is coming under 133A
Yes, that is obvious from the
and not under
assessment.
130, not under section 132 or 132A.
Yes, ma'am. That's exactly very narrow compass. That is the case. I have the
the problem.
yes. Not one see the provisions.
Right.
Not 132 is search.
Yes.
And then my lords may turn to 133A, which is survey.
The 133 is related to the inspection
Survey.
as a survey.
Yes. And 130.
But after the survey, if they found something done, then they can make recourse to us.
They have not. Here is a case where there is a reassessment under section 147 based on the survey. Those facts are not in dispute. What I respectfully submit, my lord, is that section 96, A, Roman 1, it refers expressly to 132 search under 132 or 132A.
Correct.
In a case of reassessment under 147. But expressly does not has any reference to 133A. That is my short case unless the opposite party submit that, but the order on the face of it says that, so it's a factual, that it's a question of fact because the assessment order is very clear that it was pursuant to a survey under 133.
Where is the order?
Yes, my lords will find the order.
Section 4.
Yes, assessment order starts at page 39, annexure 4. My lords will find at page 41 the background for the reassessment reopening. My lord, we'll see at 3.2.1. This is the background. So
it was a survey operation.
Yes.
133A.
Yes, of two companies where the petitioner is a director.
And where is the impugned order?
Impugned order is annexure 1, page 13. Now, there is another typographical error. It appears that the refers to assessment year 1340.
Yes, what you say? No, it's 132. Where is the assessing officer has said it's 133A, and that says that the reassessment is done this way. Then in that event, how this rejection would come that it was under 133?
Humble submission. It appears in the assessment order, the survey has been conducted, but the rejection order says passed by the
Correct.
commissioner.
It was a seizure.
Sir.
Well, I have to take this to whether the survey has been converted to, source.
The assessing officer who is having all the documents with him and have decided, can this be done in this way? You don't have all the documents with you.
No, I don't. I have to take this.
Unless you admit and then call for the records and then go through it, you didn't have. Look at the assessment, and the scheme does not really contemplate that.
Yes, ma'am.
When it refers a particular section, then any other section that is not in line with it is. Open issue. It's an open and shut case. You decide afresh. There appears to be an anomaly. We will reject this order and revert it back. Let them take the point, including this also. If they can get the materials from the record that it was really 132 or 132A, no difficult. Can take a fresh decision. But on the face of it, it does not appear to be so. Order of the assessing officer is very clear.
Yes.
So, and there is no reflection that from where you got that this is under 132. There is no reason which is refuted. Yes. Which one? Which one is this? 20.
Yes.
ma'am.
20.
Good.
This is a related assessment year 1450.
1450.
Yes, ma'am. There is a error there also. Declaration was for 1450.
But disallowance is 1340.
Yes. Impugned order refers to 1314.
Impugned order
But the-
reflected wrong.
Wrong. I have taken an affirmative.
That
That
is-
is financial year.
Yes.
It's a typographical error.
Typographical.
It is actually a 1450.
14.
I go over this year assessment year.
Which one?
Answer one. Answer one.
Oh, assessment year 1450.
Yes.
Correct.
Here it is written 1340. There is
Oh, okay.
instead.
Is a non-application. Is a non-application. Is a which authority? This election one.
Look, annexure 1 does not reflect, it is there on the portal.
Correct.
So the instruction is the designated authority under the scheme is the opposite party number 1. Principal.
The petitioner avail the remedy available under the DTVSB. What is the full form?
No, direct tax विवाद से विश्वास तक scheme.
In 2024. In respect of an assessment order, it is 2/5/2023. Passed by the assessing officer in relation to the assessment year 2014-15. The prelude to the look to availing the benefits under the aforesaid scheme. Pertains to the processing of an application under section 143 within bracket 1 of the Income Tax Act 1961 for the assessment year 2014-15, declaring the income, but on the basis of an information with regard to certain claims. The survey operation under section 133 capital B of the Income Tax Act was conducted on 5/12/2015 by the BBIT within the big INB investment Raukela in the office premises, in the registered premises of, at the registered address of the two companies, in which the SSC appears to be a managing director, and the report submitted was forwarded for unnecessary action to be taken in this regard. By an assessment order dated 2/5/2023, the assessing officer this English order. Then they get what please? 109. How can I go?
Yeah.
Straight away go to 100. Okay. Going backwards. The assessing officer arrived at the conclusion that the claim of long-term capital gain under section 10 within 38 was found to be bogus, and the sale consideration amount in respect of the associated companies introduced / credited by the SSC against the sale of these scrips of the above mentioned companies during such financial year in his capital account as his income being unexplained. The separate penalty proceedings to be initiated for furnishing the inaccurate particulars of income. The authority thereafter proceeded to decide, proceeded to assess the income under section 147, read with section 144B of the Income Tax Act. And a separate proceeding was initiated under section 271 within C of the said act for furnishing the inaccurate particulars of income. To stop. Admittedly, the petitioner challenged the said order before the CIT appeal. CIT appeals. CIT appeal, which is pending for final adjudication. Amidst the pendency of the said statutory appeal, an application under DTVSB scheme was, which was floated in the year 2024. An application was made, and by the impugned order dated 4/2/2025, uploaded on the website, such application is rejected as the aforementioned proceedings were initiated on the basis of a search conducted under section 132 of the said act, and therefore it comes within the ambit of section 96 of the Finance Act. No, 96 of the scheme act. Of the said scheme under section 96 of the said scheme. Stop. before we proceed, it would be opposite to courts, section 96 of the said scheme, which runs thus. Which page?
Page 18.
It is page 18. 96 the court code. On a manifest reading of the aforesaid provisions, the aforementioned provision, it is aptly clear that the provision of the said scheme indicated therein shall not apply in respect of a tax area relating to an assessment year in respect of which an assessment has been made under subsection 3 of section 143 or section 144 or section 147 or section 153A or section 153C of the Income Tax Act, if initiated on the basis of a proceeding under section 132 or section 132 capital A of the Income Tax Act. The order impugned indicates that the competent authority under the said scheme proceeded to reject the said application, perceiving the initiation of a proceeding being an outcome of a survey under section 132, and therefore activated the provisions contained under section 96 of the said scheme. The order of the assessing officer evinces that the case was processed under section 143 within bracket 1 of the IT Act on a survey operation having done under section 133 capital A of the Income Tax Act, and there is no reflection that such initiation was an outcome of the survey under section 132 of the same.
Search under one.
They have used the word survey or search under section 132A of the said Act. No. In absence of any material justifying the formation of an opinion that the proceeding was initiated on a search under section 132 of the Act, the authorities could not have surreptitiously arrived at the decision that it was the resultant effect of a search under section 132 of the same Act. The assessing officer has vividly and explicitly indicated the genesis of the initiation of the proceedings being a survey operation under section 138A, we do not find any justification in the impugned order passed by the competent authority under the said scheme to take a different view without recording any proper reasons in this regard. Admittedly, section 1, the proceeding under section 133A of the Income Tax Act is consciously omitted under section 96 of the said scheme, and therefore the embargo created thereunder with regard to the availment of the scheme does not appear to have does not operate, and therefore the order dated 4/2/2025 passed by the impugned in the instant appeal cannot be justified. The order dated 4/2/2025 is hereby set aside, quashed and set aside. The matter is relegated before the authority. Under the said DT, what is the full form?
DCEDS.
To decide the matter afresh. And the event. To sit matter on merit, on the basis of the documents made available to him. Made available to him. That he can assess matter. Made available to him.
There is another item, identical matter,
Which one?
within 20, the second petition, 12439.
Same order
Yes, same order. Here,
or the same year
yes,
or two companies.
they are brothers actually. The petitioners are brothers, the surveyed company is common.
So they have not spared the siblings. Order.
There is a similar assessment.
Similar assessment.
Yes.
Orders item. Item 21.
Convocation done or not done?
And it's, the matter was dismissed from the ground. Thereafter, the SLP was filed against that order. The order of this, so, audited trustee 11/2020 was set aside.
So the delay controlled.
Yes, moments.
Huh?
Yes, moment.
And the court has also opined that to be thrashed out on merit. So we are thrashing you out on merit.
It's notice as to go.
Yes, paragraph 8 of the order. What is the observation?
When having considered the matter, the court finds that the issue is required to be heard on merits. However, the court is not inclined to consider the merits at this stage, as the High Court would be more appropriate for the present for the issue to be threshold on the merit.
We are thrashing you. That power is given to us. So we are thrashing.
Notice as to go to court.
It's notice after the petition. Not on condemnation. Condemnation has been announced. Let us recall. Thanks. The application for condemnation of delay filed in connection with the instant appeal was dismissed. Was dismissed
On 30/11/2023.
on
30/11/2023.
on 30th November 2023. The ground that the cause shown therein is not convincing. The second order was received before the apex court in Was at the diary stage it has been done?
Yes, my lord. SLP diary number.
Before the apex call. Vijay, diary number 26274 of 2024. Which came to be disposed of on 24th March 2025. Whereby and whereunder. Receipt order was set aside. Semicolon. Consequently, the application for contribution of delay in preparing the instant appeal was allowed. With the specific observation that the matter to be decided on merit. Since the delay in filing the next passage, since the delay in filing the instant appeal has already been condoned by the apex court, let the notice be issued upon the respondent. Right. The liquidation amount one. But will thrash out on merit.
I'm gonna try to prevent some of its numbers.
Item 22.
Item 32, there are
Yes.
Yes, my lord. There has been a delay of 273 days in
Yes.
preparing the appeal.
Objection filed.
Objection they have filed. Objection they have filed.
They are vehemently opposing the application.
Vehemently they are not opposing, they have.
Vehemently not opposing. Mildly opposing. Mildly opposing.
The language, your lordship, may allow me to place the language. Para 4. It is relevant to mention here that the Honorable Court as well as the Honorable Supreme Court in Cabinet of Decision have held that a delay on account of administrative exigency should not be accepted unless they are shown to be justified. Entire reply I found, this is the main argument they have. Thereafter they have given some judgments, around 5 judgments, saying that they should not be condoned. That is their objection. They have
They have also indicated the Supreme Court has imposed a heavy cost.
High Court judgments, they have
Heavy cost for the involuntary delay. So be ready for cost as well. Both ways.
Sunanda Mahathur.
Madam.
Sunanda Mahathur. You state filed appeal because the Honorable Supreme Court directed for
in
semi-cost.
yes, I'm conscious. Your lordship said that I'm conscious of that. But in some other cases, Honorable Supreme Court, also your lordship sitting in this Honorable Court, have held that where the substantial question of law is there, it is to be considered lightly.
With cost. The student infrastructure, taxation matter. When revenue system is heavy,
That I have not.
with cost, that can be 3 judges, 4 line not. 2011.
That I have not wanted. But
That's kind of
as soon as that would happen.
You have referred to Sunanda Mahathur. Yes.
Let us also, if the lordship allows me. Direction, here what's your following function? Direction was the applicant for the post who have held the relaxed standard, being a candidate from the SCDC community, occupied the post of general.
Other people, respondent.
Other respondent.
Not check up. Not sir.
Private.
They were before the global
this matter. I'll take notice on these two.
Yes.
I'll take notice on these person. This one. It's not good.
And then we notice a confirm respondent to investment.
Value. This one was non-appear. Yes. Two step or tool. Yes. Reassessment to this. Good. By 2 days. By 2 days, I will submit 2 days. How will it? 24th June. 24th June. Item 23. My lord.
Here, sir.
They are leading
The side is here.
Yes, my lord.
185.
Election for surveillance.
They have not.
I have so much appeal because I filed a content petition. Yeah, ad hoc simply.
Only party.
Ad hoc
Who
employee.
responded? Give him the notice. Just give him a, serve him a copy.
Yes, ma'am.
Yeah, ad hoc employee continuing on the ad hoc basis is 95, my lord.
Yes, sir. You take a copy.
Yes, that from next week, man.
Yes, next week.
Ma'am.
Will not people take up the interim application or the read appeal? Both.
We don't know after hearing you. We go for a main matter, we.
Yeah, I'll give both the copies. IS also.
Please, yeah, at least we can.
Okay, then. Yes, ma'am. So let's. Next week, 13th. Item 24. Item 24, my lord, although there is a delay of 412 days, but the logical find from the IA that no notice was given to us. We didn't know about the order. Only after filing of execution petition, we received notice on 3/9/2024. Thereafter, only we filed the appeal. You are also may kindly see para 4 of the IA number 8858 of 2024.
Yes. Yes.
Not I am for the appellant, my lord.
You are for the?
Appellants, man. I am for the appellants.
Yeah.
Who is for the appellate?
My lord, I am appealing
for
for
the
the
appellant.
appellants.
So,
My lord, I have
Actually,
filed.
as a matter of fact, state is not a respondent to no. effective respondent.
Have you served the copy on the?
Yes, sir. Yes, sir.
Yes, sir.
Yes, sir.
Raghunath Sahu.
Notice has already been issued by the order dated 8/1/2025. Somebody is appearing probably in the list, their name reflects.
Yes, from the list I find Akshay Kumar Sahu, K. Jena, Sanjay Kumar Sahu, 3, 4, 5 advocates are appearing for Raghunath Sahu.
Number 2, 3, 4, 5, there are people.
Yes, ma'am. Yes, ma'am.
You got the brief.
Brief. I have got the brief.
2, 3, 4, 5, Mr. That's. One.
One is probably appearing, advocate Akshay Sahu is appearing because he is the main contesting response.
Name
is reflected.
Docket note looks available.
1 6 to 11.
Docket note shows item delivered at 789. That is sufficient.
Raghunath Sahu has already given.
Yes.
Then with respect to respondent number 789. Office notes, office note release, postal services, service note, notice delivered, the address, the financial plus 789. The same which you can answer.
Then is already there. What do you say about it?
My lord, my application under section 5 and 14 of limitation act, your lord.
14, why you talk about the 14? Sir?
Because, my lord, I was ignorant about the order passed for equivalent order.
Then 14 applies.
Subsequently, what happened, my lord? Eviction notice was issued to us. We have filed another writ application without as because we are ignoring about the fact of passing that order. We have filed writ application one after another, challenging that eviction notices, my lord.
So section 14 will come. Then when section 14 applies.
Instead of filing writ appeal, we have one after
Have you
another.
recall those were the wrong forms? What is the language of section 14 of the Regaulation Act? You can say that you were approaching the wrong form. Then why 40? Read 40.
The execution of time of proceedings, bona fide in court without jurisdiction.
Is it a without jurisdiction?
Not eviction notices.
I'm again asking, was the approach made to, again, there is a problem,
No,
there is a problem.
Because
Don't take me on this. There is a problem. Everybody will get confused if they read only the head note. You simply read the head note. You did not read the provision of the act. You will again be confused in future. Read what the section says.
in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision, against the defendant shall be excluded where the proceeding relates to the same matter in issue
Same matter in issue. Please consider this one. Every night, can you take a 14 here? You have correctly approached the forum. You have correctly challenged the order of eviction. This is not relatable to that. This is a separate cause of action. That is a separate cause of action. It says on the same cause of action. So
My
why
lord,
14?
why I am saying, my lord, the eviction order has been passed
This
as.
is a dependent order, maybe an independent order.
Yes, sir.
Again, I'm saying, but it's still
Yes, sir.
14 will come. Tell me. You wrote it 14.
As because the
Can you take advantage of 14? You can't.
No.
So, why the appeals are filed on this ground? They can approve the single wage, saying that there was no service of notice on me.
Yes.
It's really an ex parte order against me. Take a plea under order 9/2/13.
I am not permitted to withdraw with liberty to approach same court, my lord.
The very paragraph 2 of the impugned
My lord.
judgment is indicative that there was no service of
No need of
protection on you.
my lord.
So it is one of the open case. The petition for condonation of delay is taken out in the instant appeal. Could be on the premise that that in absence of any service of the reputation, the appellate was not aware of the issued order, which was brought to their knowledge after the further proceeding was taken up. The counsel for the appellant submits that they can pursue their remedy before the single bench, as the order impugned in the instant appeal is passed ex parte, and seeks withdrawal thereof. In view of the above, the appellant is permitted to withdraw the instant appeal to ventilate their remand before the single bench for the self-serving relief.
Item number 25.
53. First time.
First time.
Service.
Yes.
25.
26.
Item 26.
My lord, this case was before my lord on the last Friday. Your lordship may kindly see.
The copy has been served, sir.
My lord, your lordship has heard this matter on Friday, and your lordship put a question to the government advocate. You see your petition, paragraph 4 of the limitation petition, what ground they have taken. For that reason, my lord,
Yes, we have filed it.
my lord, same thing. I have gone through the additional affidavit, my lord. They have repeating the same thing.
they are laches. Yeah,
Where is that?
but they have stated in paragraph 4 of the limitation petition.
Where is that?
It's not.
Yes.
There are two copies of the. In similar matter, my Lord, Honorable Supreme Court has passed order. They cannot. There have not.
Just five cases before,
No.
this very case we referred to here. And now Honorable Supreme Court saying that merit should be factored.
However, on the last occasion,
States
my
appeal.
Lord, yes,
States appeal.
yes, state appeal. This is state appeal.
I was not a party to that, but my brother was, and then he dismissed the section 5, which went, the state went to the Supreme Court. The Supreme Court has allowed that section, saying that the merit be decided. They should be thrown out. Already.
My Lord, only my Lord, I pray that on that day, the Lordship also repeatedly say this is not convincing paragraph 4. For that reason, that took time.
On that day, this order of the Supreme Court was not brought to my notice.
This is a copy of the Supreme Court order.
Give it to me. Today they have brought it to our notice.
Sorry, my Lord. Then I file an objection to their
Objection against the Supreme Court order.
My Lord, I see it.
What I'm saying.
Sir, Surana case was referred to there. You should read that.
Yes, yes.
Following Surana
Yes, yes. My Lord,
sitting around with Justice Suddenly,
my Lord.
I was party to that.
Yes.
Discussed state of me. Now this order has come. You see what is the days of delay? 247.
257.
257. Control.
And this judgment was not accepted there.
And elaborate that petition.
So this was not to our notice on Friday. They have just brought it to our notice today. So once this petition has come, then what to do? And it is a delay of 165, less
Yes.
than that.
Yes.
We'll decide on the
My Lord.
delay will come.
When the main matter, the other parties are also there.
Only.
Huh?
Only.
Take off. So we can notice
So let-
if we can fix the matter for hearing. Yes.
30th.
You already sold it.
Sold it. Sold it.
So
We wait the notice.
Item 27.
and was posted as Hujulkat in the district of Ganjam. He was transferred to the block, Barpani block on 21/1/2025 under Annexure Minor at page 35. And the respondent seats were transferred from Barpali block to Bhadli block. The petition, the appellant joined, you also can come to page 4, my lord. In the page annexed 4, page 62. The appellant joined at Barpali block on 18 to 2025, and the respondent seats was released to enable him to join at Bhadli block under Bargaon district, my lord. That respondent 6 joined, your lordship kindly, this is important, joined at page 64 in Bhadli block. He challenged the transfer order before this honored court, filing this writ petition number 5258 of 2025, my lord. Without issuing any notice to the present appellant, my lord, that order was set aside and it was directed to revert back the present appellant to his original place after 2 months of discharging my duty in Barpali block. Only the ground it has been taken by the honorable single judge that he is going to retire up to within 1 year, my lord. On 34 2026, he will retire. He relied on the circular, which, my lord, I have annexed. That circular is there, my lord. He has annexed it at page 56, my lord. No notice was issued, my lord. Now I will go to the river. I will go back to Hindu Katmal in Ganjam district after 2 months discharging the duty, after bringing my baggages and family members to the Barpali block. No notice.
They will compensate you for providing the cost of transportation of those baggages.
No illegal, there is no illegality in the transfer order. There is no illegality in the transfer. It is chain transfer. The lordship can come to page 35, my lord of duty. It is transfer. I am at serial number 4. Arpan Kumar Pujari.
Who is for the other side?
The first time it has come.
And first time the notice has to go to the writ petitioners, my lords.
No,
No,
not a writ petitioner.
No, my lord, they
it is
are
an
responding
appeal.
to
But
the-
is that how long or how far the court can interfere in the transfer matter? The scope is very limited. When the court cannot substitute that what is required to be done and how it is to be done.
My lord. If no statutory provision is violated, my lord.
There is a statutory provision for transfer.
Transfer, my lord, there is no statutory.
Should not be.
That it is an incident of service, my lord. Transfer is an incident of service. Even notice was not issued to my lord. That only that on 19 to 2025, when the writ petition was admitted,
The writ petition filed by the city, respondent numbers
6.
6.
Yes.
Before this, there are 2 writ petitions, that's why I am asking.
Another writ petition is respondent 7. That is another writ petition number is. Yes,
You have filed another appeal.
no, I have not filed because I am concerned with the Barpali block.
So you are concerned with the Hasda or you are concerned with
The first case.
what? Hasda or Mahapatro?
Mahapatra, Saroj Mahapatra.
What I'm saying? In WPC number 5258 of the reports. Is allowed by the approved order with the following directions, paragraph 8 of the code. The appellant who was arraigned as a party in the said writ petition was not served with a notice.
Yes, madam.
Was
No
not
notice
served
was
with a
issued,
notice.
madam.
And the said writ petition going to be disposed of in his absence. The edit of the directions pass in the said petition as refused here in our. It is a legal point whether the court can interfere with the order of transfer issued by the authority. And the mannerism in which such a direction is passed inculcated a sense of usurpation of the powers exercised by the administrative authority under the fiat of Article 126 of the Constitution of India. We thus find that a prima facie case is made out. There should be a stay of the portion of the impugned order which concerns the judgment rendered on WPC 5258 of 2025.
Yes, ma'am.
Till the next date. Issue notice on the respondent number.
Response 6 and 7.
Which 7?
6, 7, because 7 had been made party in the writ petition, therefore that notice is to.
Six and 7.
7. Yeah, in the writ petition, you had made. Right.
What we
Certified copy may be dispensed. I'll serve copy of it. Extra copy I will serve. Notice by register.
1 to 5.
Okay, sir. 28, ma'am.
Copy may be granted in court of day or
No delays.
Oh, stay application.
application is there. IN number,
Were 29 for dispensing with the.
my IN number 2296, done record my first day.
Oh. Why it is not uplifted?
2296.
2296 is there.
Yes,
So
it is on record my.
it's not very 28.
Item 28.
Here you also see the last order. Last order, you also see is 9/4/2025. After having pending our
Yes.
after having pending the affidavit filed by the state on 6/3/2025, your lordship on 9/4/2025 passed an order asking me to give status report in respect of 3 districts, Bargarh, Keonjhar and Kendrapada.
Yes.
About that, your lordship may kindly remember that fake certificates, they got appointment, everybody has been thrown out. Criminal prosecution have been initiated. Some have approached this honorable court and some cases are pending. And about midday meal, there is the allegation is not true at all.
Closed out that part.
That has been closed down. In terms of the lawsuit direction, I have got instruction prepared, but it has not been shown me. Can it be tomorrow or day after? The officer couldn't reach. Your lordship can see.
You are saying in the meantime, put it on affidavit so that it will be a part of the report.
You can serve the copy in the meantime.
Yes,
And
Mr.
then next week.
You can.
Then
Mr. Das, additional government advocate. Yes. The petition was passed upon the respondent authorities on 9/4/2025 to submit the status report in respect of 3 districts, namely Bargarh, Keonjhar and Kendrapada. He submits that he has received the report, but But it would be proper that the same is put in the form of an affidavit for which he seeks time. Then let this matter be list this matter in the next week. To enable the respondent to put in the status of the aforesaid districts in the form of an affidavit.
Item 29.
P9, my lord, your lordship will find the impugned order at page 16. It starts from page 16. But the relevant portion your lordship will find at page 18. It starts from page 16, annexure 1.
Yes.
The relevant portion your lordship will find that the honorable single judge, relying on a judgment rendered by a coordinate bench, which is Patitavan Datta Das, versus State of Odisha and others, has disposed of the petition in light of that judgment.
That was confirmed in division bench of this court.
That has been now held in SLP.
Supreme Court has not granted stay.
No, yeah, your lordship is correct. No stay has been granted, but it has been.
Division bench confirmed.
Yes. There is no dispute about that. That is WA number 777 of 2020. That I remember.
So that was the no more coordinate bench.
Proceedings have been stayed.
Also, the rules are that's was confirmed in this
Division. And contempt proceeding has been stayed by the honorable Supreme Court. That order I have enclosed. That order.
So same thing. Amalgam trial and
Now these two judgments have now in the meantime
Yes.
been.
Well, in this case, I'm appearing, the facts are different. This Patitavan Das, they are taking the shelter under Patitavan Das, they have filed this writ of appeal, my lord. 2013, I have been regularized after completion of 6 years of service, my lord.
Where is the order of regularization?
Page 47, my lord. This appeal they have annexed, page 47. They have, I have,
Page.
47, my lord. E/4. E/4. My lord, that is my regularization order.
Or what?
E, my lord. After D, E. 47. my
May.
lord.
Go to page.
May.
68.
May.
Copy of the notification.
2/12/2013, the services of the,
Hmm?
my lord, they have annexed it.
Wait.
Page 47 in my writ of appeal.
E by.
Oh.
2/12/2013, my lord. I'm a peon in the collectorate.
You are DPR.
Oh, my lord. And I have been regularized in 2/12/2013 by the order, my lord. And this was been revoked in 2015 under page 52. And I have deposited whatever excess I have taken.
Whatever. So it was regularly, they were regularized. They have regularized. It was
Regularized.
in 2013.
And there, my lord.
Then where
And
is the order of revocation?
My lord, that page 52, annexer I/4, 10/1/2015.
Page 50.
2, my lord, 5/2,
Yes.
I/4.
Yes.
I/4.
This one.
So it has been within 2 years.
My lord.
That's what you did.
Then, thereafter, my lord, I didn't approach this court challenging that order.
So
Because I have approached them after completion of, I have appointed 2007. I have approached this court in 2022, after 6 years passed thereafter. 2015, they have recalled. So, and this honorable court, because that's a sanctioned vacancy. Whatever that Patitapan Das they are showing, my lord, that is no sanctioned vacancy for data entry operator. Here vacancies are created by the order of the sanction of the His Excellency Governor. That is also annexed, my lord. And I am continuing
Created before or after?
before, my lord. They have
You're joining as a temporary employee.
2007. 2007. I have joined as a contractual peer.
Correct. Against the sanctioned post or what? You say the post is sanctioned.
Yes, against in lieu of the regular vacancy, these contractual vacancies have been created, and I am, my lord, that is at Annexure 7, page 70.
7-0.
70.
Okay.
2007.
No, my lord, and 70, Annexure
Where
7.
is that?
Here.
In 2007.
And
2007, my lord.
91. 91.
This one, what is it?
Creation of 17 posts of peon on the for the district of
That was
In-
2000.
7, and I have appointed in 2007, my lord, as a contractual peon.
When?
That's my appointment order, my lord.
No, this post was created on contractual basis.
On contractual basis.
So this is not a regular sanctioned post.
That's, my lord, that is that the government of Odisha has surrendered all sanctioned posts and created in lieu of the contractual post. So, and taken a policy that those who will complete 6 years of in interpreted service, they will be regularized. That is also they have annexed, my lord. At annexure page 61, 2013 circular. Thereafter, this circular, page 61, my lord.
Yes.
61, that is the circular. And 62, clause 2, my lord, last line. The period of 6 years shall be counted from the date of contractual appointment prior to publication of this resolution.
Where do I get?
And page 62, clause 2, regular appointment of the above categories of contractual employees shall be made on the date of completion of 6 years of service or from the date of publication of this resolution. But thereafter, this has made a rule. 2013 contractual group CD rule. That is not that is also repealed in 2022.
Maybe that is not.
But that rule is not applicable to me. I'm not saying my 2000 against the vacancy which is created, I got appointment and I was continuing there. But from 2007, my lord, and they have once regularized me, and that has been revoked in 2015. Thereafter, I have approached this honorable court after completion of 6 years as per the 2013 rule. Now, this honorable court directed for regularization. Now, against that, they have filed this writ of bill. And in view of, my lord, this Jago and Sripal, this writ of bill is not at all maintained.
What for the respondent?
I'm for the
Oh, you have hijacked the right to begin under order 18 rule
Because
not on them.
I am
I
mostly.
thought you are for the
No.
appellate. So I was just trying to understand that
Sorry, my-
here you are criticizing the judgment, right? I was really figuring out that
Sorry, I'm
this
more,
insufficient would grant
I am
you want to
mostly
criticize
affected.
the
That's
judgment.
why. My lord, I am mostly
But you were
affected.
praising this judgment, so I was really
Sorry. I'm mostly affected. That's why I'm
oh.
really not getting salary.
Mr.
Actually,
Das really kept quiet and did not really interrupt it.
he has nothing to say.
Nice.
Never. What? Why? How can you?
Because, my lord, that letter of the government advocate also annexed here wrongly. My lord, kindly see that. Page 60. What the letter of the AGA.
Let them. Why you are taking up all his right? He is the appellant. He will first argue that what point he has, and you have started arguing that he has no point.
Sorry, my lord.
Let him make a point. Then you trash him out.
It's only Patitavan that they're saying. That's all. That's all.
Let them. They have not uttered. You have really extracted some word from his mouth, which he does not have. May not.
Yes, submit.
He will not. He will not take a Patitavan. He will not. He will argue on a different score. He will argue on the proposition of the constitutional this judgment of the Umadevi. Can any judgment of a lesser quorum override the constitutional decision? Tell us.
My lord, Umadevi, my lord, in Jago judgment, they have
Jago is of the lesser quorum. Umadevi is of the larger forum, 5-judge bench.
That's my lord, that's,
And this is of a 2-judge, which will prevail, 5 or 2?
no, Uma Devi is in my favor,
Where?
that I am against a sanction
Then
vacancy.
before 2005, you should be rendering 10 years of service.
Even
You came in existence after Uma Devi. And Uma Devi says that even a irregular or illegal, no appointment.
And my appointment is governed by the 2013 resolution, my lord, ruled by the government.
You were appointed in 2007, there was no resolution, there was no rule. So your initial appointment was wrong against the Uma Devi 3. How can they regularize it?
Maybe, my lord, that is maybe irregular, but not illegal. That is the Jago judgment.
That is where Uma Devi, please read paragraph 53 and 54 of the Uma Devi.
Thereafter,
What it talks about, it says that any appointment which is made prior to coming in force of this act, because there were earlier judgment of the Supreme Court, which talks about the regularization. He says that whoever has rendered more than 10 years before coming in force of that act, this judgment, without any order of the court, voluntarily, upon undergoing a regular process, but there was some infraction. They did not follow some of the provision, but they followed substantial part of the provision. Then those appointments would be regarded as an irregular appointment. And for that, the one-time measure, some scheme is to be adopted by every state so that they are regularized. Those who have been appointed without following any rules, illegally, they do not have any right.
Right.
And then Uma Devi in paragraph 56 or 57 says, henceforth, because it was a prospective overruling, henceforth, their case should not be any appointment on a contractual basis or ad hoc basis.
No, I'm not ad hoc.
Without. So the Supreme Court, the judgment has to be, you are appointed after Uma Devi.
After Uma Devi.
Wrong committed by them.
Then.
That is why it was revoked.
That's
so you cannot take advantage of the wrong.
My lord, that is the case. I am saying, my lord, because Jago judgment that has been taken.
It's not binding on us. We are still bound by the Uma Devi.
Because Uma Devi has no role to play in my case.
No role.
Because government has created post. I will say, my lord, Uma Devi.
M.L. Kesri is against.
My lord?
M.L. Kesri judgment of justice.
M.L. Kesri judgment says, my lord, that is the creation of post. If there are long service rendered, I am 2007 appointee. So M.L. Kesri is always, my lord, Justice Gopal Goda. Justice Gopal Goda rendered that judgment.
He is saying, let us see, test whether that is the correct
2006
understanding. Correct understanding by 2006. Volume 4
SCC page 1.
Page 1.
4 SCC.
My lord, before that, my lord, this.
No. After that. Your case is after that.
Yes, no.
Not before.
I just, that's one paragraph I need to read, my lord. It is well established that the decision in Uma Devi does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentally.
What was the fact? These were appointed prior to Uma Devi.
My lord,
for a long time they continued and then say
that without following a procedure of selection procedure. My case is I have selected through a procedure and by virtue of a resolution, my lord.
It is a very, very dangerous when you usurp the power of the other side.
Say whatever.
Really dangerous.
That. Absolutely.
Very dangerous.
The High Power Committee report they have annexed. There is no reason at all.
Not an anticipated case, but you have made out a case to admit and put up for hearing. This requires hearing.
With this,
Then we will admit and stay. No
So
difficulty.
now it is for admission.
My lord,
Whether to admit or not to admit.
it is a pure, my lord, is no, that's
So-
why I'm,
So,
because it's now heaven, the government is mighty and he is
you do
against
not
this.
know what they want to argue. We may not have accepted, but the way you argued, now I find that they have a point.
My lord,
So then we have to admit.
Because-
Let it before hearing.
there are lots of reasons, my lord, because high power committee minutes is also annexed here without assigning any reason. So reason is the soul of every administrative order. There is no reason why that will be revoked.
Reason has been assigned that no procedure has been followed while giving appointment. That is the reason assigned.
In small cases, they are filing readable and my lord, this manual stab in.
Paragraph 50 of the Uma Devi is the key.
My lord,
Paragraph 50 of the Uma Devi reads. The strong words.
may I read my lord?
No, you read yourself.
My
I've
lord,
already read.
the argument empty. And what is this 50 is right? There is no selection. There is illegal appointment. I am appointed to it.
Is that appointing without following, was there a white publication? Was
Yes,
there a
everything.
rule? Was there any
For
rule?
class 4, there is no rule.
There is no, that is what the court says.
For class 4 appointment, as on date, there is no rule by the government of Orissa.
So this is what is the court has said in that.
My appointment is thoroughly legal, following the
Yes.
selection procedure.
What selection? There is no
They
rule.
are not stated in writ of
If
it.
there is no rule, then what is the selection? Procedure.
That is the intended candidate peons, those are going to be selected as a committee, my lord. They have not stated that ground in the writ of it.
Have you followed the Reassessment judgment of the Supreme Court in making a wide publications and inviting applications under Article 14 and 16
That,
of the Constitution?
my lord, that
Everybody
is,
should be given
that is
equal
not-
opportunity in public
kindly-
employment.
kindly see page 7 of the.
Thing. Yes, we admit the please. We
My lord, he lost will, my lord, for a moment, my lord, this appeal, my lord, last occasion, Justice Raman was part of this, and the last order kindly be seen.
yes.
The Chief Justice stated that,
Jaco was taken into consideration. So I want
my
to
lord, this is a
Jaco
frivolous application.
that shady or that
My lord, this is a frivolous application.
Shipa judgment both will take.
My lord, this is a frivolous application, and it was the observation, and we will pass order on 16/5, my
We
lord.
will have, my brother is correct. After hearing both the sides, we will arrive at the conclusion that it is frivolous, but not at this stage of admission.
No, no, for your lordship, my lord, that was that's a judgment reserved from 16/5, my lord, 2024.
What judgment reserved?
So on 16/5, 2024, judgment was reserved.
Where?
On 16/5, my lord, that is the date, my lord, indicated. Judgment reserved.
Not by.
And 10/1/2025, it was released. That is my precarious condition.
Wanted to go further.
Yes, my lord, that's on 16/5, there is the order on May 16th last year. That day they're not releasing my salary, and 10/1/2025 it was
Yes, ma'am.
16/5 there, my lord. 16/5 it was resolved by hearing the government side. Then it is stated that it is a will pass an order for the government. Then my lord, my lord, from that day they're not giving the salary. That is my. I am not, my lord, against your lordship hearing. Yes, my lord. But they have stopped it after the judgment is not.
Let us pass the same order in the light of further judgment of Sripal.
As your lordship,
What has
yes, my
passed in
lord.
order in relation to a Jaggo, we are saying Sripal has
It
also.
is, yes, my lord, Sripal also I have. It is my prayer, your lord, that prayer from this side, order from that side, my lord. I'm not in there. But the point is that she is
Please consider.
the class 4
Twice
employee.
you have been, I
My
think,
lord, Sripal also they here.
made aware of certain things, but still, then.
My lord, class 4 employee not getting his salary. The two IS officers tussle and his regularization is revoked. And that is not also we are challenging. Because that is not within my knowledge when he has come here.
Only one line, I'm submitting. Honorable Chief Minister disposed of the petition relying on the judgment. That judgment has been now struck up in the Honorable Supreme Court. Honorable Supreme Court has passed an order not to proceed with the contempt. That is annexure 10 at page 76.
No, they have filed a detailed counter before the Honorable Single Bench. It is not that on fresh admission stage.
What?
But a counter file.
Not civil file.
Page?
76. Annexure 10.
That's a different case, my lord.
No different, how can it be?
This is not
What is there?
This is in relation to Somnath Mahapatra.
No, yes. 1086, your lordship will find at the top. WA number 1086 of 2022.
1086.
Yes, that is the case of Dr. Das. Patita Abanta Das, which has been referred to by the Honorable Chief Minister.
Stand to that.
Sorry.
Stand to this. That.
Yes.
This case also bearing to this case, my lord.
When you say that.
That can be, that is the counter affidavit they have filed.
77 para 4.
The Honorable Signature has relied heavily on the very judgment which judgment is before Honorable Supreme Court pending adjudication. So this matter should also
Wait.
Every regularization matter, Patitavan Das order, they will annexed and filing a writ appeal. My lord, writ appeal number is 2604/2023. My lord, 2000 writ appeals against every single bench order.
Yes.
My lord, that's why my case is that your lordship may consider my submissions in the light of that two judgments have recently passed by Honorable Appellate Court. Even if the outsourcing persons, they cannot be sealed as an outsourced person and their regulation, they should be considered for regulation for long years. From 2007, I am uninterruptedly serving. My lord, there is no rule governing the field of class 4. It is only your credibility. First, you have to be appointed and not expecting anything. Then your character will be looked out and then you will be given a contractual. And here in this case, there is a selection process. There is everything. They have not stated in their writ appeal. There is no selection process or their recruitment is illegal or nothing.
In the counter we have stated so. Why?
No, in the writ appeal, they have not stated.
It has been stated.
In which paragraph they have not a single paragraph they have stated that this in the event the resolution dated 17/9/2013, where under which I have the respondent number 1 appointed, are confined to employees, are appointed on contractual basis only and cannot be extended to the respondent number 1 who have been serving daily wage basis. That is the only case they have stated. And nothing else that recruitment process and as your lordship is saying, it's contrary.
While the friend is submitting something factually incorrect.
For the single bench, you have stated.
Yes, page 37, your lordship will find from the counter. Page 37, towards the last portion of that page. About 4-5 lines from the bottom. According to the collector who operates before the regularization order of service of the petitioner by the applicant so. Further, on 29/2021, the High Power Committee once again rejected the case of Dr. Bhai on the ground that proper recruitment procedure was not followed. We have stated that.
And documents called for before the single bench. My lord, you will also kindly see page 21. My lord, before that, my lord, page 21, last line of the impugned judgment, which is also not disputed that the petitioner was appointed on regular vacant post on contractual basis. And my lord, finally, the proper recruitment process by opposite parties should have been violated initial regularizing the service of the petition. Further, it appears that while revoking the order number, no opportunity was also provided to the petitioner. Oh, natural justice followed, that's why.
Notice the conclusion of the petitioner and observe that the petitioner also the decision of the support. I mean, the case of the versus this so far has already been taken by the decision of this person. The law laid down in the case of Bacterias versus Spiritus. So the complaints finally to such contents. This the single bench as directed the police practice to consider the case of the petition. Now the essentially parties there and the appellate parties being approved have come up with this court confirming that the very judgment this is a relied on the civil case that is is when the case is subjudice before the report in SLP number. SLP number 6. Annexure
Annexure 10.
10.
At page 76.
9 of 23. Analyzation of said this method shall be restored.
Mention.
It's tomorrow, it is posted for before the honorable apex. On 7/5 it is posted.
Item number 30.
We have that. The application.
Please, your Lordship. Well, item 30 is one IA which has been withdrawn. IA 1 is government. Who are you?
Well, I'm for the appellate. What is the Public Service Commission? On the last occasion, well, some interveners had appeared.
Oh, yes, that is what I want.
Well, I haven't got the respondent. It was my learned senior Mr. Samal who is appearing for the respondents. He has informed me that he is on his legs today. There's a matter fixed at 3 p.m. Your Lordships may.
They are fixed at 3 p.m.
He's in court 12 today. He's on his legs. Your Lordships may have this in the list tomorrow.
What time? Let us see for the time being. Let us see. Yes. Keep it in the next week. Yes.
Right. Item 31.
I am appearing on behalf of respondent number 7 before advancing argument on behalf of the appellant. Just I want to point out before Lordships that the interim order passed by this honorable court is being deviated by the citizen. Lordship, kindly see the interim order passed by
What does that mean?
Lordship, kindly see the judgment passed by the honorable single judge was passed on 13 September 2024.
Where is the order?
Judgment, your Lordship will find at page 40.
Page
40.
40.
My lord. 30th September 2024.
13th September.
My lord. The respondent number 7 was given appointment pursuant to this judgment on 25/10/2020. Pursuant to the said judgment.
September 24.
My lord, 25/10/2020.
So there was a direction
But to give appointment.
to engagement.
My lord. You will.
Engagement is done.
In the post of Anganwadi worker.
Or whatever. The engagement has been done.
Yes, on 25/10/2020.
Okay.
My
Then
thereafter, my lord, notice in the aforesaid appeal was issued to respondent number 7. Respondent number 7 appeared, but registry didn't show the appearance of the respondent number 7. That is the fault of registry. Therefore, on that ground,
Cause this to obtain was not.
not
detected.
my
So you must.
on that ground, on that ground, the opinion number respondent number 7 has not appeared. Interim order was passed on 6/3/2025. You also kindly see the 6/3/2025.
where is the
Order.
In this aforesaid appeal, you also. In this appeal.
order? Where was it?
My
Order dated 6/3/2025.
Yes.
Order number 3.
Respondent number 7 goes unrepresented.
My lord. Even if the respondent number 7 appeared by that date. The operation of para 19 of that judgment was stayed.
Something that where the direction was made for your re-engagement.
Re-engagement.
There is the study of the opinion of paragraph 19.
Paragraph
19.
But to give appointment. By that time, appointment was given.
That what not there revoked.
No. What has appointment? I brought this fact before this honorable court that I had appeared but it was due to fault of the registry, my lord, my name was not appearing in the cause list. Therefore, my lord, it was modified on 11/3/2025. Your lordship may kindly see. Para 3 of that order. 11/3/2025. Stay of operation of para 19 in impugned judgment should not cause any fresh action to be taken in the meantime. A fresh action means subsequently, from that date, no fresh action or no cause of action will be arose by the state government. No step will.
Engagement.
Yes. But what has happened, the CDPO has withheld my appointment, even if not allowed to work whenever Anganwadi worker is concerned. No. 26/3/2025, your lordship may kindly see. This is in Odia. Your lordship may not. I will. One. Your lordship may kindly see, it is in due operation of that order on 6/3/2025. This order is passed without considering the order of 11/3/2025. And it is on the persuasion of the appellant. Appellant knows that I have been appointed. Without disclosing that fact, the order is taken.
Lordship, ma'am, please, your lordship.
How can it be done? Engagement has already been done.
This is reference to 6/3.
6/3 only. Even if it was brought to, they have not considered, even if it is produced. Even I have personally telephoned to that CDPO. That order is passed, you don't touch. I have personally, my lord.
Can I got the power to, a private party got the power to telephone the CDPO? My lord, I am not
Yes, he should have been informed. He should have informed.
Who am I, lordship, to advise him? It is the state lordship. I am the private party. I say it's above.
What he says, we appreciate it. In the moment you got the order of stay, it was your obligation to communicate immediately to all concerned. You communicated to the state also. That yes, there is a stay order which is passed.
Lordship,
You did not communicate
it was a read appeal in front. I have never communicated to anybody.
6/3 order you have not communicated.
I have never communicated in front of the state. It was order. State has communicated.
But I will file affidavit, my lord. He has communicated.
Yes, who is this?
Now, lordships.
It is not continue.
It has been
Why
communicated.
salary is not, remuneration is not paid. 11 parts order is very categorical.
11th March.
But I am sorry about it. But I'm sorry.
It's only reference to 6/3.
So the order is modified in 11/3. There is no-
This has to go. This has to go. हाँ subsequent date नहीं
Yes, sir, how can you?
it has to go.
May I start the appeal? Let's
Start the appeal, no difficulty, but her demands has to be taken care of.
the state has to take care of
Your lordship, I may be allowed to continue. Thereafter, your lordship may hear. I may be allowed to continue, your lordship. Yeah.
Let's see. This is in regard to the appointment of Anganwadi worker. Let's see. Guideline says for ASP area, there should be a
candidate must be belongs to ST and SC. Now, notification issued at page 13 inviting only ST candidate. I'm making English translation. Page 13.
Where is the English translation? Well, I will be deprived of my
No,
privilege.
give me one day time. I'll make it English translation. By tonight I will do it English translation so that it will be convenient. It holds the field because this will be very injustice for me also. Lordship, depriving my lordship. It will not be good for you. Because three letters are in Odia, I'll do the English translation. Next Monday, let's see, Monday or Friday. Resident. She is not my client. She does not belong to that area. That's why the Lord Collector and ADM heard.
Why she does not belong? After the marriage, she has gone.
No, she is not married. Not directly, she has selected not belong to the service area as per the
She has
guideline.
got any relation with the marriage.
No, but there is no relation. She is not married here.
Say directly appointed, so it has got no relation with the marriage. Even a marriage.
Even married, but that is not his plea. Pandarapada, second line, let's see. Pandrabadi, page 40. Again. Pandrabadi. Let's see. Last one, Pandrabadi. Then let's see. Her page 16, her certificate, it is Pradhan Pada, page 16, let's see. My learned friends plant certificates belong to different way.
That is PS
Khajuri Pada. The rule says
must be resident of that.
That where Anganwadi center is situated. She is not belong to that area. That's why the learned collector kindly see the order of the at page 21, the ADM order, page 21. Let's see, may I read page 21 of my opinion? That the respondent number 2, that is the CDPO Khajuripada, had published advertisement number 359 dated 30th/6/21 inviting application only from ST women candidate for appointment Anganwadi worker in Pandrabadi Anganwadi Center under the Adarsh Pada GP, along with 4 other centers of different GPs in the district of Kandhamal. There are 77 families in Pandrabadi village, out of which only 3 families belong to ST category, the rest belong to SC category. The appellant Sujata Digal belongs to SC candidate community and having certificate of my client ignores in the child food nutrition qualification. But he has been debarred to compete for the post of Anganwadi worker due to illegal advertisement published by Harassment number 2. no ST candidate is there for our center, is there for in the Anganwadi center in Pandrabadi village is functioning. But the SC candidate have been ignored as for thereafter, the CTPO Fulbani has published advertisement 3 inviting application from both SC and ST category, whereas the respondent number 2 has issued advertisement for only ST category, which is illegal, unfair, hence liability to cost. Then let's see relevant is.
But the what? You are not talking something else, but the offenses have not gone into this aspect.
Best.
It has gone into the aspect whether there was any advertisement for SC or ST. And then in the event there is no candidate of ST, then whether it can be filled with the SC.
Yes, that is what at page 19. That is what at page 19. Page 19. Page 19, Office of the Collector has passed the order. Page 19.
Yeah.
And let's see, got it? Page 19. May I read, let's see, fourth paragraph? Page 19. Whereas peruse the PWC of CDPO Khajurpada. Let's see, got it?
Yes, I got it.
Yeah. The CDPO stated in a PWC that as per government in WC department guideline issued by letter number 82 dated 4/1/2010 and letter dated so and so, the advertisement published for Anganwadi worker in the Pandrabadi Anganwadi Center, Adashipada Gram Panchayat of Khajuripada block from among ST candidates belong to AWC service area. But in the instance case, Srimati Subhasmita Kaur.
He does not belong to that area, service area.
That's fact. Therefore, she is not entitled.
Then she challenged this order before the higher authority. Page 21.
Page 21 is the ADM order.
So he is higher.
He is the higher authority. ADM quest for
The highest authority. So this order is challenged by them before Red Court.
Writ Court.
The Red Court, what it says.
Writ Court says, let's see, the ADM order passed by the ADM is illegal.
Correct.
Therefore, I
say why it is legal.
Because illegal in two fronts, let's see. One is the guideline says, let's see, advertisement should be for ST and SC. If ST candidates are not available on the area, then it will be open for SC candidate. If SC candidates are not available as per the guideline, then they will jump to another area. Here, without inviting SC candidate, they have simply jumped to ST candidate area. That's what the order.
Advertisement must have indicated that for LM I am doing the SC and ST, all candidates must have applied. If they find that the ST candidate is not there, then they have converted into an SC.
SC.
And if the SC candidate is found,
and here it is a reverse. What my lord is asking me, here it is reverse.
My lord and friend is misguiding to that is not the fact.
we hope that we will be misguided.
But my lord and friend, I am sorry for it. My lord and friend has made wrong statement.
So let us understand, we have read something.
Only my lord, the advertisement is meant for ST candidate because it is a TSP area. It is the tribal sub-plan area. The advertisement is meant for ST candidate. Correct. Only ST candidates will be given appointment. As per the notification, if ST candidate will not be available in that area, nearby area. So I am belonging to nearby area. That is the finding of the honorable single.
Let's see, can you see the guideline? Page 30, let's see. Page 30, the guideline. But I am saying guideline.
13 or 30?
30. Guideline issued on dated 2/5/2007. Lordship, I am turning to the next page. Relevant is page 31. Read B. May I read, Lordship? In all tribal subplan area, only ST candidate will be selected as Anganwadi workers. This is important. In case no suitable ST candidate is available in Anganwadi areas, that it may be open to the ST candidate also. Now has to be read with clause 6. The Anganwadi worker, clause 6, Lords, is a volunteer who gets an honorarium for the service rendered by her to the less privileged person of her community. She is not a government servant with fixed or guaranteed pay scale. Therefore, the provisions of ORBB Act, SC/ST Employees Act shall not apply in selection of. Similarly, an Anganwadi worker cannot claim any regular appointment in future on the basis of. However, preferences shall be given to SC, ST and SC candidate in the scheduled area. This is what my point, Lords. My point is privilege should be given for ST, thereafter SC. Now the application invited at page 13, Lordships, is only for ST. Now the candidate which she was selected, she is not belong to Anganwadi center. Lordship, that is page 13. First clause is, Lordships, Sampukta Bhakti, man, the candidate must be belong to the Anganwadi tribal subplan area. Tribal subplan, only ST and SC, tribal subplan area.
That guideline is, 25/2007. It is superseded. You know the guideline which has been dealt with by Honorable Single Judge. It is, your Lordship will find at page 53. Para 14 of his judge. This is superseded. This guideline is no more. My Lord is showing. Your Lordship will kindly see page 53. Is 4/1/2010.
That is, I have annexed 9/4/2010 guideline. I am coming slowly. 9/4/2010 guideline I have annexed. What my learned is friend prior to that. I am showing the guideline on 9/4/2010. Lordship, that in case revised guidelines, Lordship. Lordship at page 36. My whole case, Lordship, I am unnecessarily taking my Lord for reading. Let me tell in 2 minutes. In whole case, my Lord.
What your whole case? Your contention is that there was an advertisement made for engagement of an Anganwadi worker who cannot be equated with the government service, not the statute applicable to a government service with employer, nor they will claim any right in the future. But in order to fill up the post or engage the Anganwadi workers, the advertisements have to be made as per the guidelines which is issued by the government. Now the guidelines says that there are TSP areas.
Lordship.
In the TSP areas, only the ST candidates which are required to be appointed. So they
with the caveat
that if there is no eligible or suitable candidate in ST, then it can be converted into SC.
Lordship, that's precisely my
point.
point.
Say that so far as if the guideline goes silent on that, but section 6 is very clear that the preference will be given to a SC or ST. Then according to you, if the ST candidate is not found, even in a TSP area, then it should be filled by an SC candidate.
Lordship.
If both SC and ST is not found, then you can hover around to a nearby area. So you are saying that I being an SC candidate of the same area, how can you hover around to
that's precisely my point.
And you left the post? What do you think that if you did not get it?
Lordship, that's precisely my point. I am grateful, Lordship. I was seeing that my Lord is reading.
That my Lord is under
No, Lordship, on that, not on that. Lordship, not on that, Lordship. I'm humble, Lordship. No, I was thinking there are certain
We
ODA.
are reading certain provisions that whether what you say can be justified from the different guidelines which is issued.
Lordship.
We got your point.
Lordship.
We are looking at 9410, 2010, also the clarification.
Lordship.
So I was reading that.
So, Lordship, what my learned friend is saying, revised guideline on all these things, it is only based with this first guideline 25/2007. Nowhere it is stated in the TSP area, only ST candidate will be taken. And now all the records I will show, Lordship, I have annexed all the invitation. They have said ST and SC. Lordship, in page 62, kindly see their advertisement. In TSP area, ST and SC.
Yes, we continue.
May I read the judgment, operative portion of the judgment in view of this wrong in the judgment, Lordship. My case is, Lordship, without considering this aspect, I am belong to the scheduled area. The authority has jumped. This honorable court, learned single judge, did not consider this aspect, Lordship.
Yes.
That is, Lordship, starting from page 48. Let me read slowly.
Yes.
Sri S.K. Parida appearing for the intervener would submit that the advertisement was issued restricting the same to only ST candidate, which violates Article 14 of the Constitution of India in view of the clear guidelines of the government that in case of non-availability of suitable ST candidates belongs to the service area, SC candidate can also be considered. The ADM therefore rightly found the advertisement to be contrary to the guidelines and therefore interfered with the same. That's it, got it, page 48 I'm reading. Para 8, Lordship.
Yes.
The facts of the case are not disputed in as much as both the parties are ST candidates and having applied pursuant to the advertisement were found suitable for appointment. Further, out of 5 Anganwadi centers advertised, candidates were selected and appointed in the respect of 3 centers. Long after such engagement, the advertisement dated 30th/6/2021 was held to be not as per the due procedure and guidelines issued by the government. The impugned order, however, does not whisper as to what effect withdrawal of the advertisement would have on the already appointed candidates, because it is treaty law that the
Yes.
Though, page 49. Though it has not been stated in so many words, yet on a plain reading of the impugned order, it would imply that the entire selection process has been held to be bad in law. This is unacceptable because firstly, the impugned order was passed without hearing the affected parties, namely the 5 selected candidates, including the petitioners. Secondly, the ADM appears to have lost sight of the fact that the appeal was filed a person who was never a candidate but subsequently questioned the advertisement after completion of the selection process. If at all the appellant was aggrieved by the advertisement, then she should have challenged the same before the appropriate forum, authority at the relevant time, and at any rate.
Did you file an application pursuant to this advertisement?
Yes, Lord. I have filed an application for which ADM consider my application.
When the advertisement was
Made.
did you file?
No, because advertisement only belong to ST. I am belong to SC. That incorrect advertisement.
What is incorrect?
Yeah.
If it is TSP area, then only SC.
ST and SC. Guideline says ST and SC.
Advertisement will not indicate. If it is a TSP area, then it is restricted to ST.
ST.
The ST candidate of the same locality is found, then he will be appointed, SC will not.
Oh, SC will not.
So you did not make an application.
No, because advertisement, kindly see the advertisement. My challenge is the advertisement.
Whatever.
My challenge is the advertisement. Advertisement, kindly see page 13, the advertisement.
Yes.
This is what in ODI. Advertisement I did challenge before this honorable. This honorable court gave me the liberty.
When?
Immediately after this advertisement, this honorable court gave me the liberty. Lordship kindly see liberty to file.
The selection process is over.
To my knowledge, I did challenge before this honorable court. Honorable court directed me to appear with the learned collector. Collector disposed of the application. Thereafter, I preferred going to the ADM as the authority. ADM granted application in my favor. Thereafter, my
You should be appointed.
Lordship, yes, I am. The theory is I am higher qualified.
Did not apply for that. You did not apply for that post pursuant to the advertisement. How can you give an appointment? There will be more highly qualified person or belonging to a ST or an SC of the same locality. Who knows?
No, there is nobody. Nobody, no.
You know all the village persons.
No, Lordship, Lordship, this is the finding. This is the finding.
Sir, two things. If if I accept your petition, then there's two things here. First thing is that at the time of advertisement, keeping in view of this clause 3A and the 6, the advertisement must indicate that in the event the suitable candidate belonging to SC is not found within the locality, then it can be filled up with the SC candidates.
That was my prayer.
All the candidates belonging to ST and SC of the area should apply with condition that SC's application will not be considered if the level ST candidate is found of that.
Let's
First, they could have done. They did not. Second is, if there was no suitable candidate found of ST of the area, the advertisement is restricted to ST only. Then it was open to the authority to make a press advertisement inviting application from the SC of the area.
They did not
Because
do
there
that.
is no,
They did not do that.
so in both the situations, you are not entitled to get a job.
My prayer was to
That
pass.
thing will go.
My prayer.
Only thing is that he will be away. His engagement will go, but you are not entitled to be engaged.
My
Absolutely not.
my
He will not engage you.
my.
Endeavor is to pass that advertisement.
Let's see, because not as per the guideline.
He will watch it. Then you go, he goes. No. They will do a fresh advertisement. What is it? No engagement. His engagement will go. We have to say so. Is there any other choice? Tell us.
If the state can accommodate both floods. I am the most suitable candidate.
So, like you.
Yes.
Nobody is there except me. I am the most suitable candidate. Chotia gaon, Latsi, small village, nobody is except me. This is the only meritorious candidate. No, what is that ADM says? Learned ADM says. No, learned ADM says. No, not learned ADM.
My humble submission before Lordship is advertisement is for 5 posts, 5 Anganwadi centers. 5 persons are available.
We are concerned with this.
If the advertisement will go, 5 persons will go.
Oh, advertisement to the
Area.
It is
Mandravadi.
it is my lord, fact is different. My lord, it is for all. It is same for all.
No.
Your Lordship may kindly see.
Others have not found the challenge.
No, your Lordship may, others have come forward.
They have come forward.
My lord, this judgment is comprising out of 2 orders passed by the Honorable High Court for 2 persons. No, my lord, your Lordship may,
Only Pandravadi.
Into 5.
Only Pandravadi.
no, your Lordship may kindly see. Your Lordship may kindly see. My lord, what has happened on the similar facts and circumstances, your Lordship may kindly see for him. On the similar facts and circumstances, 2 petitioners were.
Show me from the guideline that it can switch over. One line.
My lord.
I am again saying, I am with you. If you can show me one line that it can switch over to nearby area. No difference. ST.
Yes, your guidelines, my lord, guidelines is there.
So was anywhere, by this time I tried to go through it. I did not find a single. Neither 4.1, nor 9.4, nor 2.5. I could not get it.
My lord, it is there.
Please show.
It is there, my lord, the guidelines to 4/1/2010. My lord, the affidavit was filed by the state.
4.1 is also there.
I have annexed. Page
My lord,
35.
my lord, that is the state has filed the counter with that guideline.
Is that I have opened it. First, that it talks about this. Please.
My lord,
Please.
your lordship,
Yes, yes.
my lord, your lordship may kindly see this. By 6, the state had filed the counter.
No, we are at Please, we have opened screen, you can see, we have opened this.
That is when 18/7/2000. My lord, this is the clarification. No, that is subsequently, my lord, in the year 2022. You also may kindly see the clarification. My lord, 22.
22 is not here.
So 18/7/2022. You also may kindly see this.
Yeah, amendment of 2021.
My lord, fact is different. What has happened, my lord? I am just.
That was prior, 21.
This advertisement is 2021.
No, you will also may kindly see for it.
What was the guideline prevalent 21?
21, you will not see.
Sure, sir. Anywhere, sure.
My lord, just a minute. Just a minute, I am showing it. But just I am briefing the fact so that it will be.
Not necessary. The facts are very clear. Sir, admittedly, you belong to ST category of a nearby locality.
My lord.
Show me that you are in there. In terms of the guideline. That's true. You just show me that it is permissible. We are with you.
That is also not available in the revised guidelines. That is not there.
There is nothing.
But that is, I have sent that 2010. Well, 2010 here, man. But I will show to you, lordship.
You should us from the bench.
4/1 2010.
I think we don't have to waste anything on fact. Anything on.
Is something different. That is confined to women, not this man. Women. That is confined to women.
What has happened, my lord? What has happened? You lordship may kindly see. You lordship may kindly see. Just, my lord, I am just clarifying. I am. Yes, your lordship.
That area, nobody was found.
I will come to that.
You are nearby area, you were found.
My lord, not that the 5%, 5 posts that has been filled out by that way. The 5 posts, my lord, the 5 posts which has been advertised in the under Annexure 1, but all the persons, my lord, have been given appointment by that way. You also may kindly.
They belong to the
ST candidate nearby area. ST candidate nearby area. You will also. No, that is.
We are concerned with you.
No, my lord, 2 persons. Here, my lord, 2 persons like that. It is described here. 2, my lord, here it is in the judgment. It is in the judgment, 2 persons in the same similar manner. You will also may kindly see. In the year 2021, advertisement was published. Again. But advertisement was published, my lord, 5 Anganwadi centers. Five Anganwadi centers, my lord, advertisement was published. What has happened, my lord? All are selected out of 5, my lord, 3 Anganwadi centers, the 3 persons were given. My lord, just my lord. My lord, 3 were given. My lord, the total advertisement was caused by the ATM. That is the whole problem. He has challenged. My lord, once, my lord, they have challenged the total advertisement. The appellant, my lord, the appellant has challenged the total advertisement. And the ATM had caused the.
Can we not pass a partial decree? Under the law, if a person has come and say that the whole building belongs to me, and the court found that no, only a eastern portion belongs to him. Can we not pass an order that eastern portion belongs to you? So he may have, but if we find that your appointment appears to be in doubt, then cannot court say so? What are you talking about, sir?
My lord, you will also may kindly see page 22.
What?
That is in the nearby village, it will be considered. Page 22.
Which guideline shows?
My lord, as per the partial, as per the dated 2/5/2007. Page 22.
Yes.
That as per partial modification to the guidelines in letter number such and such 25/2007, amendment has been made in para 1 as follows. In case no woman is found eligible from those residing in the service area, then women from the other parts of the same village will be considered.
Yeah.
If no woman is found eligible from the village, then women from other villages of the same gram panchayat will be considered. Yes, it is for ST. This the on as per the considering this manner, subsequently it was set aside by the ADM. It was brought to the notice of the ADM. Women in ST area, your lordship, it is completely in ST area. Your lordship may come to above. At para 3B of the revised guidelines, communicated in letter number such and such in all tribal subplan area only.
There at page 30, I've shown this.
That was before the ADM. And moreover, my lord, ADM has not given us the opportunity of hearing. That is the finding of the Honorable Single Judge. And my lord, this challenge has been made after selection process is over.
For relying on this, let us interpret this. That what is the effect of this particular modification of the guideline of the period 2007. Correct? In conjunction with the other guidelines 3A and 6. You have to harmonize both.
Sir, read this 4/1/2010 caption head. A partial modification of the revised guidelines for selection of issued by this department letter number 25/2007.
Right, it is this, my lord.
Read clarification issued so and so letter. I am to say the following may be appended. So that appendix has come as para 3B of the revised guidelines. That is confined to tribal subplan.
Yes.
So tribal subplan, we are confined to this.
Exactly, my lord.
So general, this is exception.
My lord, this is not to the to my lord. Your lordship may come to later. The said amendment has been brought. Your lordship may come to as per partial modification to the guidelines in letter number such and such. Amendment has been made in para 1 as follows. This amendment is made. This amendment has been communicated in letter number 82 WCD dated 4/1/2010. So this portion is of 2010 amendment that which is read by your lordship. That is the para 3B. So it is of the year 4/1/2010, which is not mentioned in the. It is not the 2000. It is of the 4/1/2010. And my lord, that my lord, this guideline which is said.
According to you, if the movement is not gone, it can over around level the area.
What is the subsequent consideration of the Honorable Single Judge? You lordship may kindly see. Just move. I may be permitted to the para 9 just. Para 9. What is the consideration? Exact consideration.
Yes.
The facts of the case are not disputed in as much as both the petitioners are ST candidates. Well, 2 writ applications were there. It is this is for 2 Anganwadi center area. 2 writ applications there. It was heard. And having applied pursuant to the advertisement were found suitable for appointment. Further, out of 5 Anganwadi centers advertised, candidates were selected and appointed in respect of 3 centers. Long after such engagement, the advertisement dated 30/6/2001 was held to be not as per due procedure and guidelines issued by the government. The impugned order, however, doesn't whisper as to what effect withdrawal of the advertisement would have on the already appointed candidates, because it is trite law that the selection process and the selection of candidates follow the advertisement. My lord, advertisement is for ST candidates. Though it has not been stated in so many words, yet on a plain reading of the impugned order, it would imply that the entire selection process has been held to be bad in law. This is unacceptable because, firstly, the impugned order was passed without hearing the affected parties, namely the 5 selected candidates, because total advertisement has been caused by ADM, including the petitioner. My lord, secondly, the ADM. My lord, secondly, the ADM appears to have lost sight of the fact that the appeal was filed by a person who was never a candidate but subsequently questioned the advertisement. My lord, third is, my lord, it is without jurisdiction. ADM has no power. Your lordship may kindly see. The candidate but subsequently questioned the advertisement after completion of the selection process. he had not applied. She has questioned it after selection process is over. If at all the appellant was aggrieved by the advertisement, then she should have challenged the same before the appropriate forum authority at the relevant time at any date before completion of the selection process. The intervener opposite party number 7 not having done so should not have been permitted to challenge the advertisement after completion of the selection process, and therefore the ADM committed manifest error in interpreting the same. Second, third is without jurisdiction, but the appellate, the ADM is not the appellate authority. So he has passed the order. So therefore it is without jurisdiction, and this is dealt with. Another important aspect is competence of ADM to invalidate the selection process after its conclusion. In this regard, it would be apt to refer to the revised guideline dated 2/5/2007 issued by the government in W&CD department, wherein under the heading procedure, the provision of appeal has been mentioned. The relevant clause is extracted herein below. Sub-collector will be the appellate authority for hearing complaints regarding selection of Anganwadi workers for tribal and rural projects. And additional district magistrate will be the appellate authority for complaints regarding selection of Anganwadi workers for urban projects. On a plain reading of the aforesaid provisions, it is clear that only complaints regarding selection of candidates of Anganwadi worker can be considered by the ADM as the appellate authority. No further power is conferred on the ADM. What the ADM has done in present case is so far as exceed his brief by invalidating the selection process itself. It is well settled that exercise of power by an authority which said authority doesn't possess tantamount to abuse or discretionary power, tolerable exercise of power. Reference matter, the decision is relied upon. It has been argued that the appeal was filed pursuant to the order passed by this court in WPC number such and such by intervener opposite party number 7. Perusal of the order dated 9/9/2021 passed in the aforementioned writ application revealed that a coordinate bench of this court, after noting submissions made by the State Council that an appeal lies against selection and engagement of Anganwadi worker, was not inclined to entertain the application, but granted liberty to the petitioner to approach the appropriate forum ventilating her grievance. Obviously, another aspect.
Whether those grounds can be tenable.
Another
The utility of the appellate court is to verify, to scrutinize, to consider whether the judgment of the single bench is correct or not.
Another point.
Bound by the decision. Otherwise, there is no purpose of.
Another point I will argue with Lordship is, another point is, my lord, I am a bona fide selectee.
Yes.
I have not committed any wrong. My lord, there is a 2013 Supreme Court and 2021 Supreme Court. Penalized, and I have been given appointment, and I was working for some, I have undergone training. So for that matter, I should not be. So 2013, if you lordship permit me, I will supply that 2013 and 2021 Supreme Court.
It's an item.
But I will be permitted to give that two judgments. Mine.
Not fresh admission 7, 8 lotships are directed. We will take taken up tomorrow. Tomorrow lot. Yes.
But it's only thing we request your lordship that tomorrow the matter can come because 45 is mentioned.
Item 47 also, the covered judgment.